All right, good afternoon, everyone. This is a time and place set for a workshop before the Nevada Game Control Board for the possible action regarding proposed amendments to Nevada Gaming Commission Regulations 5, 7A, 8, 9, 14, 16, 22, and 28. Madam Secretary, has this workshop been posted in accordance with Nevada's open meeting law?
Yes, it has.
All right, then let's proceed with our first item of agenda is public comment.
This item is placed on the agenda to give the public an opportunity to comment on gaming-related matters. Anyone wishing to address the board may do so at this time. Comments by each person are limited to 3 minutes as a reasonable time, place, and manner restriction. If board members ask questions of the speaker, the time needed to address those questions will not count against the speaker's 3-minute time period. If speakers have any handouts or written copies of verbal comments to provide for the record, please hand them to the enforcement agent seated to your left in Las Vegas or behind you in Carson City.
Thank you, Madam Secretary. Matters brought up during public comment cannot be acted upon by the board, but we of course want to hear any public comment that you may have, as well as comments from my fellow board members. Let's start in Carson City. Is there anyone in Carson City wishing to make public comment today? I don't see anyone, so let's go here to Las Vegas. Anyone wishing to make public comment today, and that doesn't mean that you need to make comment on a specific item that will be on the agenda. You're welcome to at this time, but you will also have an opportunity to provide comment on that specific proposed regulation if you want to do that later on in the agenda. Anyone wishing to make public comment? Any board member wishing to make public comment? Seeing none, Madam Secretary, that will close our public comment section. And have any regulation comments been posted that you have received, Madam Secretary?
We received one last-minute comment in support of the proposed Regulation 22 changes. It has not been posted just yet, but it is in process. If the public would like copies immediately, they can contact my office and we will provide it. And there should be copies in both of the boardrooms either now or soon.
Okay, and that's regarding Reg 22, correct?
Yes.
Okay, so we'll have time for that because that won't be the first item on the agenda. So there'll be certainly time if the public wants to see that document. Also, as a little bit of housekeeping, I want to tell everybody we're not going to go in numerical order today, and to give you a little preview so you can follow along. This is the order we're going to be going in for a number of scheduling reasons today. We're going to take regulation 5.240 first. Then we're going to go to regulation 8.130. Then we're going to go to regulation 9.010, regulation 22.060 and 22.115. Then we will take regulation 5.260, regulation 16.010 and 16.405, then regulation 7A, regulation 28, regulation 14.010, and then finally regulation 5.102. Mr. Ross, did I get those in the correct order?
Yes.
Great, thank you very much. And if there is reasons that we need to take anything out of order for economy or people in the audience, we can do that. But that's the general order we plan on going in today, in case anybody has a specific item that you're interested in and want to follow along and not have to sit here as we go through the rest of the agenda. All right, Madam Secretary, please read in the first item that we will be considering today.
The first item is proposed amendments to Regulation 8.130 regarding without limitation proposed changes by PropSwap Inc. concerning sports ticket resale providers.
Thank you, Madam Secretary. Good afternoon, Mr. Rubenstein.
Good afternoon, Chair Hendrick, Member Saad, Member Watkins, Madam Secretary Mark Rubenstein, for the record, with the law firm of Reed, Rubenstein and Bogatz. Don't really have much in the way of an opening presentation. We're grateful to the board for the consideration and thought that was given to this draft regulation in its March workshop. We've been corresponding with the board separately in regard to any unanswered questions and requests for information that were asked of us at the initial workshop. We hope that we've certainly tried to answer all the requests to the best of our abilities. We hope we've done so adequately. The biggest question I think that was asked of us, and probably the most difficult, is what are the unintended consequences of this proposed regulation amendment. I don't know that we have really come up with anything to answer that, but I do think that the question's not so significant when you take away the fact that we are no longer seeking to change the definition of a wager. And so by simply adding the ability to register and essentially register betting ticket resale providers and tying them to a licensee by way of agreement, we think that it's a pretty tidy, simple regulation. We don't believe it opens any regulatory gaps. We believe, as we said at the earlier hearing, that it's better to have this activity regulated. Prop swap, and by the way, if I didn't mention it at the outset, I am here representing Prop Swap, which is the proponent of this regulation. We don't believe Prop Swap would continue to do business, and it has not continued to do business as long as the board believes this activity to be illegal. But it does leave open the ability for illicit operators to continue to trade in this activity without the benefit of regulation. So we do think that this is a plus for the state. One of the questions was, well, how does this regulation pay for itself? And the issue of taxation was raised. PropSwap also has no objection to the imposition of a gross gaming revenue tax on its receipts, namely the commissions that would be charged by the registrant and or licensee. So we don't believe that that's an open issue any longer, and are willing to work with the board to see how best to accomplish that. We've given you information in terms of the state of the law in other jurisdictions where PropSwap does business. The only conclusion we came up with from a 30,000 foot view is that it's a mixed bag. There's no single approach that any state has taken to this activity, although most of them have viewed the PropSwap transactions as being outside the scope of their jurisdiction. In other words, not a gaming transaction. We're not here to fight that fight any longer, and are willing to proceed as a registrant tied to a licensee. Lastly, we reviewed the revised draft, and we have no comments. We find it satisfactory.
Thank you, Mr. Rubenstein. Senior Deputy McKella, is there anything you want to add before we take further comments from the public?
Thank you, Mr. Chairman. Good afternoon, Chairman Hendrick, Member Watkins, Member Saad, Madam Secretary. For the record, I'm John McKella with the Attorney General's office. I think we pretty well covered it at the March 7th hearing. I do want to again put on the record that these proposed changes are before you today based on the settlement agreement between the board and PropSwap approved by the chair pursuant to the delegation of litigation authority to the chair. And based on that agreement, PropSwap dismissed an appeal it made to the Nevada Supreme Court in return for your fair consideration of PropSwap's proposed regulatory changes. You satisfied the board's agreement to give fair consideration of the changes during your consideration of PropSwap's proposed changes during the March 7th workshop, when you considered PropSwap's proposed changes for over 2 hours. As Mr. Rubenstein stated, he gave you all the stuff you requested at that March 7th hearing. The changes between the draft considered at the March 7th workshop, and today is we changed the term sports wagering ticket to betting ticket. This is in line with the term of art used elsewhere in the regulations in the mix. It was discussed on March 7th that this term should also be defined in Regulation 1. However, this is not needed as Regulation 22.050 clearly sets out the parameters of a betting ticket. At the request of the Enforcement Division, the requirement to provide the board with copies of agreements has been changed to a requirement to maintain copies of agreements. And the term sports pool has been changed to book. This term encompasses both sports pools and race books and would allow transactions involving non-parimutuel race wagers. These changes from PropSwap are before you today for your consideration. The possible actions you may take today are: 1, recommend PropSwap's proposed changes to the Commission for adoption as proposed. Recommend PropSwap's proposed changes to the Commission with modifications. Direct me to draft modifications to PropSwap's proposed changes to bring back before you at a later date. Refer the matter back to staff for further consideration, or finally take no action. And I just want to clarify for the record, the draft before you today is dated May 8th, 2024. And that is all I have to put on the record, but I'm happy to take any questions. Thank you.
Thank you, Mr. McKellar. I'll start, and Mr. Rubenstein, you're welcome to stand there or sit down, whatever you prefer, and we can call you back up. I appreciate what Senior Deputy McKellar said about the litigation history of this, but I want to be clear for the record that that was not my intent of going through a lengthy process. And you gentlemen from PropSwap being here back in March and showing up again today means a lot to me. That shows that you care about this. I'm sure I said on the record then, and I will say again, I am a big believer in new concepts. I'm a big believer in entrepreneurship, and you guys have found a new mousetrap. So I applaud you for that. I said some other things on the record, which I won't rehash, but I still have a number of concerns about this activity in Nevada. And that's why, to me, this wasn't about fulfilling something that was part of a litigation settlement. This was really about me, from my standpoint, trying to figure out, is this something that the Nevada gaming industry needs? Is this something that the customers in Nevada need and want? And so that conversation we had back then, I think, was robust. Mr. McKellar said it went a couple of hours. I didn't remember that, but it was certainly a very thorough discussion. We asked for some additional information, which you provided to us, and I've gone through all that, and thank you for that as well. As I said, though, I'm still concerned about things that I think are being put over to the licensee side, the know your customer, the source of funds, those kind of things. And appreciate you gentlemen saying that you know your customer, but I'm in a quandary of, if this was possible, why wouldn't Nevada licensees do it themselves? And I can tell you that I haven't had a Nevada licensee come and say, we'll do that. What you're probably hearing in Nevada and other jurisdictions is early cash out, which is not your mousetrap, but it's a similar mousetrap. And I think that's going to be a bigger consideration as the sports wagering industry explodes. I also think that the idea of, and we had this conversation, the customer is going away from paper tickets and going more toward mobile. And we had a conversation about, where does that leave your company? Where does that leave your process? And so that's just still gives me more questions than answers. Nothing away from everything you provided. And Mr. Rubenstein did an excellent job of providing us with this information. And certainly I want to open it up to the public. But before that, I want to open it to the other members of the board and see where their feeling is today. And feel free, board members, Mr. Rubenstein, Mr. McKella, and then after you have questions, I want to see if anybody else in the public wants to ask questions or provide comments as well. Member Watkins?
Yes, thank you, Chair. Similar to what you mentioned, I still have ongoing questions related to these types of transactions. I think with more industry support, it looks like I didn't see any letters of support from the industry. Can you confirm whether you guys received letters of support from the industry?
Come on up, state your name for the record and spell your last name.
Ian Epstein for the record, Epstein. I don't recall that as being something that, was something that you were looking for us to do, to go out and get letters of support from the industry. I do know for a fact that our attorney, Mark Rubenstein, spoke to the NRA and had I forget which committee it was, but he did it, based on what occurred last year. We wanted to speak directly to the NRA, and he did that, and there was no objections from the NRA. I think last time we spoke about different partnerships that we had with different casinos while we were active in the state. Most notably, we had multiple partnerships with the owner of Circa / the D and Golden Gate. I don't want to speak for them and say that he would have given us a letter of support if we asked for it. But we had many conversations with many casinos while we were active, and there was this kind of chicken or the egg scenario where they wanted to work with us, but they needed support from the board, right? So hence why we kind of started going down this path of, we wanted to be licensed, we wanted the registration, and they didn't want to partner with us until they knew that there was no going to be risk to them to partner with us as, an unlicensed business. So it's this chicken or the egg scenario where the casinos are looking for support from the board, and the board is looking for support from the casinos, and we're kind of caught in the middle. And so that's why we are here before you today to seek licensure or registration, so that we can then start to approach these casinos, craft these commercial deals. Because look, there's a scenario here where we go down this path and we create a new registration, and then casinos say we don't want it, and then we're in no different position than we are today. But at the very least, we are coming there and at least shutting the door on any sort of argument they could make about, well, how does the board feel about this?
And I agree that there certainly was no requirement that you provide letters from the industry. We didn't state that, but I do remember us having a conversation on the record about, perspectives from the industry. And it wasn't clear to me that they were in support of this.
Well, as I mentioned, Mr. Rubenstein, he spoke to the NRA, and I would feel confident saying that if the NRA opposed it, they would have made their position clear on it. So, perhaps it's the NRA is neutral on it, but if the industry or the NRA were opposed, I do they are aware of these ongoing proceedings, and I firmly believe that they would come out and state their opposition to this.
And not that it hangs in the balance of whether or not the NRA is in support or opposed, but I also would argue that if they were in support, then maybe they would have expressed that support as well. So the opposite is also true.
Yeah, again, I don't want to speak for the NRA. I don't represent them in this matter, but it's not their method of operation to come out in support of something they're essentially just neutral on. And that was the upside or the upshot of what they means. We are neutral. We don't have a position.
What committee was that? Mr. Epstein mentioned there was a committee of the NRA.
It's the Government Affairs Regulatory Committee, whatever the one is that typically works on regulatory and legislative matters.
Thank you.
I don't have anything further at this time, Chair.
If I may briefly, because you raised it in your remarks, is that the KYC AML issue. I don't think what PropSwap does or what PropSwap would do in conjunction with A licensee alters the analysis one bit in terms of what goes on today. Books have their responsibility to do KYC due diligence with respect to customers that bet and cash out. And prop swap, while it has no legal obligation, or it would under the contract that is required to be approved, but independently does that same level of KYC diligence on its own and always has. More importantly, or maybe equally importantly, is prop swap does not transact in cash. Casinos do, prop swap does not. So if anything, the KYC concerns should be less somewhat.
Let me ask you about that. So how does prop swap take the payment?
By electronic funds transfer or check.
No credit cards.
Credit cards and credit cards, yes.
But you understand you can't use a credit card in Nevada to buy a wagering ticket.
You can't use it directly to wager. You can use it to fund a wagering account.
Yeah.
And you can use it to obtain funds in a casino at the cage.
But if I bought a ticket at a sports book in Nevada and wanted to sell it to you, and you said, "Oh, great, here's my credit card,"
right?
You think I could do that?
Yes.
Why?
Because there's no prohibition.
But the book couldn't. You're saying I could because I'm holding it in my hand.
Right.
Yeah, but the book can't.
That's correct.
Yeah.
And that's more of a compulsive gambling issue than anything else. If you look at the legislative history over why the credit card prohibition exists, it's not a concern over money laundering. It's a concern over compulsive gambling. And
which is a concern, right?
Which is
with me.
Which is a concern.
Sure.
But these transactions are more deliberative, more long-term. You're not sitting in a slot machine just pressing a button or pulling a handle. You're doing some research, you're going online, you're seeing what the odds are. There's a lot of thought that goes into purchasing a ticket for resale. It's
Sure.
not an impulse buy.
Understood. Judge Assad, questions?
Yeah, thank you, Chairman. First of all, I'd like to commend Mr. Rubenstein for a zealous and excellent representation of his clients and this issue. Outstanding job, really, very persuasive. You almost had me there, but here's where I'm at. I think when you peel back the layers of the onion, I mean, first of all, I would prefer that you would get a brick and mortar location and then just obtain a full license. But if that's not on the table, fine. When Bill buys a sports ticket from William Hill, and the odds are 10-1 on a future bet, and it's not going too good, so he wants to get off the bet. So he goes through Pop Swap, and Larry says, "I'll take that bet." It's now 5-1. There's still that element of risk. Larry is putting up money, hoping that he'll collect on a 5-1 wager. So you still have that element of risk, which to me is still a wager.
Right. And we're no longer contesting the issue of this is a wager. The regulation assumes that it's a wager.
Well, that's one aspect of it. The other aspect is I don't know how you would be able to verify source of funds, which is a concern.
No differently than a casino would.
Well, they have other requirements. Usually if it's a transaction over $5,000 in cash, they're going to get your driver's license, your income statement, whatever the case might be, a social security card, IRS return. They're going to have to, especially if it goes up into the $300,000, $400,000, $500,000 type of wagers. So I don't know if PropSwap has the ability to verify source of funds.
They do the same due diligence on KYC that casinos do.
They would obtain an income tax return?
I don't believe casinos obtain income tax returns, to be honest.
Well, compliance departments do.
I maybe in the rare case of where they're extending large amounts of credit, but not for a wagering transaction.
Okay. Well, anyway, those are my concerns, as well as I echo the concerns by the my fellow colleagues.
Well, again, my point is, I think that these, with all due respect, I think there are concerns that are addressed by Prop SWAT's business practices, and I don't think they're bona fide concerns. I don't think what they're doing makes the betting industry any more vulnerable to crime or mischief than, in fact, like I said, if you don't adopt regulation, then you're just pushing this stuff to the ground. If you really believe that people are not going to resell their tickets because we don't have a regulation, I think that's a fantasy.
Which I would certainly agree with you. We don't want to do, and that's a problem across the country.
Of course.
And that's not a Nevada problem. So we are not trying to encourage anything that increases black market wagering.
Right. So the choices are regulate and tax, or don't regulate and take chance that there's
Understood.
criminal activity.
Yeah, and
on the, if I may finish, on
Sure.
the regulate and tax side, we believe we've addressed all the concerns.
Yeah, and I want to say too that this isn't only about prop swap, and you focused on the fact that these gentlemen have an up and running business doing KYC, source of funds. But if this regulation were passed by the commission, we would have other entities that maybe don't have the history. Obviously, they would still have to be registered, but
not only would they have to be registered, but in order to be registered, they'd have to get into an agreement with a licensed race and sports book.
still need to do a
its
license.
due diligence, and by doing its due diligence and conducting its background check, would have to be satisfied that the folks that are engaging in this new business are legitimate.
Understood. And big fan of free market. If this were to be passed by the commission, I would want other companies to have every opportunity as well. I go back to, if licensees who've already have race and sports books wanted to do this, they could do it themselves in-house, and just haven't heard that. And appreciate your comments about where they're kind of neutral, and the chicken and the egg makes sense to me.
Right. And they haven't, mainly because to them, what is it? The juice isn't worth the squeeze, I think, is the best analogy I can come up with. It's a lot of work to do this, and they have limited resources, and their betting menus have expanded exponentially since PASPA was repealed, and then there's competition everywhere. Sure. And since mobile betting came along and so much of it is electronic, that, and to that point, Nevada the board historically and the commission have always stayed out of business judgment decisions. And to me, this is a question of business judgment. If the casinos felt it was, in their best business interest, they'd be doing it themselves. It's been 9 years since Prop Swap first stepped in Nevada to do this. The technology is not complex. I really, truly believe, and I don't know if any book operator wants to come up, but I really believe at the end of the day, the analysis by the books is the juice just isn't worth the squeeze.
Understood. Appreciate that. Let me open it up to anybody else in the public who wants to make comment on this particular proposed regulation. Anyone? I don't see anyone in Carson City. Nobody here in Vegas. All right. Mr. Rubenstein, I want to agree with what Judge Assad said. You've been a zealous advocate on behalf of your clients, and this has taken a long time. Personally, where I'm at, I just still don't think that this regulation needs to be in Nevada. I just don't see the need for it. I hope you're not correct that this drives the black market. That's certainly not my intent, but where I'm sitting today, I am not in a position of moving forward with this with my recommendation to the commission. But I say that also with the caveat that this is a good draft of what could happen, and I would not say that in the future this may be looked at again. But where I sit today, I'm just not in favor of recommending it to the commission. Member Watkins.
I share the chair's concerns. I share the judge's concerns. I'm not in favor of moving this forward to the commission at this time. Again, like I said, I would, even if the industry is neutral or whatever the case may be, I'd just like to see would like to see some confirmation of that. I'm not sure we fully explored the unintended consequences. And hopefully, maybe as the chair mentioned, maybe this could come forward again at some future date. But I do appreciate all the information provided, the follow-up information regarding other jurisdictions and definitions of wagers. And I had an opportunity to review that. And I'm just not at this time convinced.
Judge.
I concur.
All right, so Mr. Rubenstein, thank you. Gentlemen, thank you. Pleasure having you here again. Do wish you the best with your company. And again, not saying that this isn't something that Nevada may look at in the future. Appreciate it. Thank you. Madam Secretary, please read in our second item on our agenda.
The next item is proposed amendments to Regulation 8.130 regarding, without limitation, exempting certain transactions involving independent financial institutions from required transaction reports.
Thank you, Madam Secretary. Who is going to present this? Is it the Attorney General's office?
It is, Chair. I have this one.
Please go ahead.
All right. Good afternoon, Chair Hendrick, Member Watkins, Member Assad, Madam Secretary. Again, for the record, I'm John McKellar with the Attorney General's office. Before you today for your consideration and possible recommendation to the Commission are proposed changes to Regulation 8.130. The draft before you is dated May 2nd, 2024. The purpose of the draft before you today is to exempt loan transactions involving funds from an independent financial institution from reporting requirements. Financial institution is defined in Regulation 5.115, subsection 2G. Essentially, a licensee would not have to report loans from a bank authorized to do business in Nevada to the board. The reason for the proposed change is that these types of transactions do not raise any regulatory concerns for the board. I'm happy to answer any questions you may have. Thank you.
Thank you, Senior Deputy McKellar. You're a fine attorney. Can you break this down into layman's terms of why we're adding this?
It simply removes a reporting requirement under 8130 subsection 5. It has a list of transactions that need not be reported to the board, but for these exemptions, basically most loan transactions would have to be reported to the board. So all this does is it says if you get a loan from an accredited bank, you don't have to report it to the board.
Very good. Thank you for that explanation. Chief Linksavath, is there anything you want to add on this?
Chief Linksavath, tax and license, and I don't. I think it's something that's needed because we get a lot of reports out there for things that are just everyday type loans, like Senior Dag McKellar mentioned, like from Bank of America or something like that. We just don't have a lot of concerns with that.
So it's more work on the industry and more work on the board for something that's probably, I hate to use the word rubber stamped, but by the time it comes through, it's rubber stamped and it's just unnecessary because it's from a known financial institution.
Right. At this point, I don't think it serves the intent of what the initial regs were.
Very good. Thank you. Chief Fremont, anything you'd like to add on that?
I might just add that all the information that would come in on the 8130 regarding these loans from the bank will be addressed during our audits. And so we're already taking care of it through the audit process in the field work, and it's just unnecessary for them to submit them to us.
Very good point. Appreciate you putting that on the record. Anyone from the public wishing to make comment on potential recommendation regarding Regulation 8.130 sub N? Well, it's actually 5N. Still nobody in Carson City. We haven't had a run. Maybe we need to open the doors. Maybe there's a lot of people standing outside waiting to get in. Anyone in Las Vegas wishing to make comment on this recommendation? Seeing nobody. Member Watkins, questions or comments?
Just to comment, I'm in favor of removing this reporting requirement, given the existing regulation on these financial institutions. And also given that it would be low risk and create efficiencies for the industry, for the board. And as Chief Fremont said, that this information is already addressed in our audits, I'm in favor.
Very good. Judge Assad?
Yeah, it makes perfect sense to me, so I support it.
All right, then, since we don't have any further public comment, does somebody want to make a motion on this potential recommendation?
I will go ahead and make that motion, Chair. I move that the board recommend the adoption of the proposed amendments to Regulation 8.130 as presented in the draft dated May 2nd, 2024 to the Nevada Gaming Commission to become effective upon adoption.
Very good. Thank you, Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye, that recommendation passes. Bringing us to our next item, Madam Secretary.
The next item is proposed amendments to Regulation 9.010 regarding without limitation, clarifying the surrender of license for temporary closures, clarifying administrative approvals, and clarifying requirements for licensed gaming businesses.
Senior Deputy McGaw, good afternoon.
Good afternoon, Mr. Chair, members of the board, Madam Secretary. For the record, I'm Ed McGaw with the Nevada Attorney General's Office, here today to present the proposed changes to Regulation 9.010. After discussing the proposed changes that were presented in the May 6, 2024 draft, Dr. Watkins suggested some additional changes to the regulation. I have incorporated those changes in a revised draft which is dated May 22nd, 2024, and which is marked as revised version 2 at the top. If there's no objections from the board members, I will be working off this version in my presentation. The purpose statement of the presented agenda or presented in the agenda for this workshop adequately covers the proposed edits. Therefore, the board can move forward with this revised version without running afoul of the open meeting law.
And the draft dated 5/22/2024 has been made available to the public prior to this hearing, correct?
That is correct. It was presented at today's meeting. It had not been posted on the board's website, however.
Okay, but you're going to go through not only what was posted on the prior draft, but any changes that would be in this draft.
That's correct.
Good.
99% of the changes or 90% of the changes are just a reformatting. So really what was in the draft posted on the website matches the requirements of here. However, I will bring up 2 reporting requirements that are new.
Yeah, especially anything that you believe is substantive rather than just formatting.
That's correct.
Thank you.
Okay. And if it pleases the chair, I will briefly go through the changes.
Please.
In subsection 1, the term licensed is added before gaming establishment, and this is to match the defined term at NRS 4630169. Also in section 1, we reformat the cross-reference to NRS chapter 463B and regulation 17 to simply conform with the current format used by the NGC regulations. Subsection 2 is the meat and bones of this change. This basically takes existing requirements and breaks them out for clarity purposes into different paragraphs. Paragraph A addresses the surrender, abandonment, or quitting of the licensed gaming establishment. The provision keeps the requirement that a licensee must surrender its license to the board within 10 days of abandoning, quitting, or surrendering the gaming establishment. This is one of the new additions, is it adds a requirement that the licensee notify the board immediately of taking such action. This is necessary because the board may have to take certain actions in these circumstances, such as a closure audit. If the licensee is closing the establishment, the board needs to know so it can act accordingly. So it was felt that that was important to add that to this requirement. Paragraph B addresses the closing of gambling games at a licensed gaming establishment. And this again, adds a requirement to notify the board immediately should they close all gambling games on their premises. This is necessary in case the board has to take certain actions and also to keep it informed of certain developments on the licensed gaming establishment. Is there a reason for why they're closing the games? I think the board would want to know. Again, it clarifies that the licensee has 10 days after the expiration of the 30-day period to surrender its license. Currently, it is not clear whether the 10 days from the close, whether that 10 days is from the closing of the games or 10 days from the expiration of the 30-day period. Logically, since they have a 30-day period they can close, the 10 days should run from the end of that period rather than 10 days after closing machines, because they don't necessarily know at that point how long the machines are going to be or the games are going to be closed. It adds the term gambling before games, again, just to be consistent with the language used in the statute. It's not referred to licensed games, it's referred to as gambling games. Paragraph C adds a requirement that any request to close gambling games for a period of greater than 30 days must be in writing. Again, this is an existing provision. It's just broken out into paragraph C to try to add clarity to the requirements. Paragraph D states that a licensee's failure to comply with the requirements of paragraph A or B is an unsuitable method of operation and grounds for disciplinary action. The board had expressed problems in the past with licensees not surrendering a license at the appropriate time. This makes it perfectly clear that disciplinary action will be sought. Subsection 4 clarifies the provisions that these provisions apply to closures, or excuse me, let me back up. This is another substantive change. In the past, the board has allowed, under the phrase term, other physical destruction of the premises to include remodels or construction projects. What this does, it clarifies that those types of closures are covered under subsection 4. So it basically adds remodels or construction projects to the list of items. It replaces the term license with gambling game to be consistent with the statute as discussed in a previous subsection. And again, it corrects some cross references to the NRS and NBC regulations. This current draft added the term remodel or construction later on in subsection 4, where it hadn't been in the May 6th draft. It's just, again, to be consistent. It's not adding a new requirement. It's just making the changes complete. Section 5 of subsection 5 of the regulation replaces the term license, again, with gambling to be consistent with statutes. With that, I conclude my affirmative presentation, but I'd be happy to answer any questions the board may have.
Thank you, Senior Deputy McGaw. Great explanation. Let me bring up Chief Linksavoth, and you can do it from the side table there. Walk us through the real world reasons on why this is good for the industry and what does this resolve?
Right. For subsection 2, and that's for any type of closures that's not where they're physically still capable of opening if they wanted to. That's subsection 2. We wanted to clarify that if you do not turn in your the timing of it, which is when does the 10-day start? We've had enough questions in the past that it felt like it needed to be clarified. 2, once they did not surrender that, it also clarified that there could be grounds for disciplinary action, and we did not, and that just gives us the flexibility to pursue any kind of disciplinary action all the way from violation to revocation of a license. The real world aspects of this, it happened quite a bit during COVID. And then right after that also is that when some of these typically smaller establishments, they wouldn't have enough play, let's say, and they would close down for, a month or more, and they were unsure of what they were supposed to do. And we're just trying to help them out by clarifying everything on here. Larger places like, MGM's here, I see represented, they don't have issues with this. It's more of these restricted establishments or even group 2s that they just don't have the counsel to help out with that. And so
So when you're talking about real world aspects, what was happening is they didn't understand if they looked at this reg, what were they supposed to do and what timing were they supposed to do it in?
Exactly.
And so a lot, because of that, then they got it wrong
Right.
and we were cleaning up after the fact.
Exactly. And we didn't want them to have to then give up their license. That's a pretty drastic remedy, I guess. And I'd prefer that not to happen if they are paying their taxes and their intent is to reopen and all they had to do was just open it within 30 days, let's say, just for a day or so. Just wanted to clarify for people who don't have counsel.
Good. Thank you. Is there anyone in the public who wish to make comment on this proposed recommendation regarding Reg 9.010? Anyone in Carson City? Seeing none. Anyone in Las Vegas wishing to make comment? All right. Member Watkins, did you have questions or comments?
I have a question for either Mr. McGaw or Chief Langsavad. Am I correct in understanding that we have already been acting in accordance with the amendments provided for in section 4? And this is just to clarify what has already been done in practice?
That is correct. Currently, the board considers other physical destruction of the licensing gaming establishment to include destruction related to a remodel or other construction projects. It's just, it's been a long running policy and it's about time that it got into the regulation it's so that everybody knows what is included.
So,
it doesn't leave it up to the interpretation of what that phrase means.
Okay. Thank you for that, Mr. McGaw. And
Member Watkins, just to also let you know on that, that one, even with council, there's been questions on whether or not that applied to subsection 2 or 4 when there's voluntary construction or remodeling and those type of things. So we wanted to clarify it.
okay, thank you. Appreciate that clarification. Then I'll just comment that I'm in favor of the amendments to this regulation. And I think adding the notice requirement helps to keep the board informed and take any action that's necessary from our end. And just make us aware of what operations are open or closed in the industry, as opposed to waiting 30 days or an extended period of time to even be provided notice.
Thank you. Judge Assad, questions, comments?
Thank you, Chairman. In addition to the substantive changes, I see it as basically just some cleanup to parallel 463069. So I'm in support of it.
Very good. I am as well. And I have dealt with tax and licensing and Chief Langsavoth as we've had some of these issues come up in the real world over the last year and a half that I've been here. And anything we can do to help the industry and their counsel, or especially as the chief mentioned, those who don't have gaming counsel understand what process they need to do. So thank you to Tax and License Division and the Attorney General's office for hopefully cleaning this up and making it easier to read and understand if anybody ends up in this scenario. So definitely in support of this, and I would entertain a motion.
I'll go ahead and make that motion, Chair. I move that the board recommend the adoption of the proposed amendments to Regulation 9.010 as presented in the draft dated May 22nd, 2024 to the Nevada Gaming Commission to become effective upon adoption.
Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye. Motion passes, and that recommendation will go to the Nevada Gaming Commission, bringing us to our next item, Madam Secretary.
The next item is proposed amendments to Regulation 22.060 and 22.115 regarding, without limitation, the establishment of reporting methods on wagers on events whose outcome has already been determined.
And this is mine, Chairman Hendrick.
All right, Senior Deputy McKellar, please go ahead.
Good afternoon, Chair Hendrick, Member Watkins, Member Assad, Madam Secretary. Again, for the record, I'm John McKellar with the Attorney General's Office. Before you today, for your consideration and possible recommendation to the Commission, are proposed changes to Regulations 22.060 and 22.115. The draft before you is dated May 6th, 2024. The main purpose of the draft before you today is to require reporting when a book accepts an ostensible wager on an event whose outcome has already been determined, and to clarify when approval from the board chair is necessary to rescind a wager. Both of these proposed changes flow from discussions with licensees regarding how to handle the occurrence of a book taking money for a wager on an event whose outcome has already been determined. The change to Regulation 22.060 subsection 3 would require reporting such instances to the board. The change to Regulation 22.115 clarifies that books do not need chair approval to rescind a wager if such rescission is covered by a book's house rules. In review of the transcript from when the commission adopted this section in 1989, it is clear that this was always the intent. Including the current proposed change will ensure that all licensees are aware of such intent. Also, you should be aware that licensees will not be able to impose any unreasonable rules regarding the rescission of wagers, as Regulation 22.150 requires chair approval of a book's adoption or amendment of its house rules. Given the new reporting requirements would require reporting an instance of past post wagering within 1 week after acceptance, I would suggest a little bit of lead time in the effective date for these proposed changes, perhaps September 1st, 2024. And with that, I'm happy to answer any questions you may have. Thank you.
Thank you, Mr. McKellar. And as well, I have gone back and did as much research as I can, as you mentioned, back to 1989, when there was a change and the adoption of the regulation that says the chair must approve any unilateral rescission of a wager. And as you mentioned, I believe all along what the intention here was, and it's borne out if you read through the regulatory history, it's if the house rules weren't clear on it. And house rules were discussed as being a contract with the patron and being sure that the patron knew what it was. And this goes back to, there was a written parlay card that happened back in, I believe it was even prior to 89. And that's really what they were focused on. The world of sports wagering has changed a lot since 1989, and the speed which transactions happen, mistakes may happen, all makes sense. And it's certainly not a burden on the chair to approve these rescissions. I receive them sporadically. I wouldn't say it's a common occurrence, but when I do, I review them very closely. I look at the facts of why they're asking for a rescission. And I would state for the record that I have never denied, since I've been here, the ability to not rescind them, because they were based on appropriate facts and appropriate behavior. And the regulation was forcing the licensee to actually come before the Gaming Control Board chair and say, this happened, but I need you. And we do these very fast. Enforcement reviews them very fast. They get to the chair very fast, but it still take a couple of days. And by the time that happens, the world now with electronic wagering, electronic accounts is just moving very fast. And so we want to be sure that we're keeping up and not creating a burden on licensees or the patrons to wonder how this works. Makes more sense to me, as you said, Mr. McKellar, the book has to have approved house rules. And if those house rules say in there, this is not a wager, this will not be an accepted wager if this circumstance occurs, then there's really no reason to wait a couple of days to have enforcement review it, to have the chair rescind it. It shouldn't be a wager to begin with. And I believe that was the intent when you go back and read what happened in 1989. I want to hear from my fellow board members, but before I do that, I want to open it up to the public. Anyone here who wish to comment on this drafted proposed recommendation, please step forward. Mr. Rubenstein, pleasure to have you here again, and certainly know you've gone through the history of this as well.
I have, Mr. Chairman, and thank you. For the record, Mark Rubenstein of Reed, Rubenstein and Bogatz, appearing on behalf of Red Rock Resorts and Stations Casinos. we applaud the direction that this regulation is going in. We just have a few comments with respect to the language,
All right,
if we may.
please.
So basically, the comments are threefold. Number one, where it says instance of acceptance, we think that the proper terminology should be purported acceptance, because we don't want to acknowledge that it's an accepted wager, even though ostensible is intended to
State that again.
where it says at the beginning of
Yep.
the first new language, book shall report instances of acceptance of such ostensible wagers. We wanted to insert the word purported before acceptance. Instances of purported acceptance.
A book shall report instances of purported,
My apologies.
P-U-R-P-O-R-T-E-D,
Yes.
purported acceptance. Do you think that would clarify or confuse people as to what purported acceptance would be?
Well, the lawyer in me says it clarifies things.
Good. Good. Purported acceptance.
And for the record, I'm not paid by the word.
Good. A book shall report instances of purported acceptance.
Chair, if I could just chime in real
Please.
quick. I think the word ostensible added prior to wager. I mean, the ostensible wager is being accepted, right? So it's arguable whether
Well,
purported is necessary.
to me, that's an oxymoron. That's why I think purported is helpful there, because acceptance of an ostensible wager. Well, is it a wager? Is it not a wager? If you put in the modifier purported, then it's obviously we're basically saying, well, it wasn't really a wager.
So who would be the action of the verb purported? A book shall report, that's easy. Instances, that's easy, of purported acceptance.
Right. So-called acceptance. Alleged acceptance. I'm alleged acceptance.
So still the actor
Parent
there.
acceptance. That just the acceptance is because acceptance contradicts the ostensible.
Mhm. The actor, though, would be the patron.
Right.
Yeah. Then a book shall report instances of and then you don't have to include these words, but it would be a patron's purported acceptance.
Well, it would actually be the book's
it would be the book, right?
book's purported
Yeah.
acceptance, yes.
So
And it's really meant to deal with the mobile wagers and online wagers that happen instantaneously without a human necessarily laying eyes on each and every attempt to make a wager.
I also went to law school a couple years ago and don't get paid by the word, but alleged.
That's fine. I just think it needs a modifier because I think saying acceptance.
It wasn't accepted.
Acceptance, yeah, it indicates that it's contradictory to ostensible.
Okay.
But in action, from my perspective, it was accepted.
Right, but then you get into the whole metaphysical thing of, well, it was illegal, and so therefore it couldn't have been accepted
Right,
as a matter of law.
It's the difference between legal and actual physical acceptance, because the wager is actually being accepted. I just think it adds more confusion, honestly. But
And if I might, for the record, to support Member Watkins' statement, I pulled up the definition of acceptance, and it says being such an appearance plausible rather than demonstrably true or real. So I think the word ostensible from my perspective covers it, but I will, of course, defer to the board.
Well, we're just making that as a suggestion.
What would be your concern if it didn't have the word purported or alleged?
My concern would be, well, you're suggesting that the wager was actually accepted, but you're telling me it never was a wager.
Because of the house rules.
The house rules, because it was an illegal.
But you already have the modifier ostensible.
I understand. It's belt and suspenders, and to me, it's just to help modify what is an apparent contradiction in my mind reading that sentence. But again, not the hill to die for. I do think it makes it better. If other people, reasonable minds disagree, I'll move on to the next drafting.
Yeah. Let me ask you a question. Does it need the words acceptance of such ostensible wagers? A book shall report instances
of such ostensible wagers.
Of acceptance of, or wouldn't it be a book shall report instances of ostensible wager.
There you go. And you just save
Yeah,
the
see,
state
I
a
get
lot of
paid less
money.
by the word.
A lot of print got saved right
Yeah,
there.
yeah, save some trees. Yeah, I think about that Attorney General's office, Mr. McKellar, is instances of acceptance of such, the word such would modify the fact that we already know about them, which we do in the previous sentence, right? A book shall not knowingly accept money or its equivalent ostensibly as a wager upon an event whose outcome has already been determined. A book shall report instances of such ostensible wagers not later than 1 week after acceptance to the board's enforcement division. Yeah, you got the word acceptance twice.
Well, I was going to get to that.
Yeah. Okay. Okay. Go ahead. Go ahead. Go ahead. Go to your second point.
Yeah,
We'll put a pin in the first.
The second point was that what should trigger reporting is discovery by the book. These things are not always discovered when they immediately occur. Maybe a day or two, sometimes longer. There have been instances where it's later found out. For example, that a wager was past posted. So we were going to suggest that it not later than 1 week after discovery of occurrence.
Rather than acceptance to the board's enforcement division, I too am a little confused by that wording. How would the board's enforcement division accept them if they didn't know about it? Okay.
Maybe if we add the requirement to have known or should have known, because I'm afraid that if we just remove that requirement altogether, the 1 week after requirement, then you would essentially be given an indefinite time period to discover, because you should know if you're doing your.
Yeah. Look, we have a third point. I think the bottom line of all these is we probably shouldn't be drafting at the podium.
Yeah.
And, I'm more than happy to sit down with any one or more board members in the Attorney General's office and try and clean up the language. And
let me back up then. Conceptually, I think you started by saying you're in agreement that this helps solve a problem. And that's what we're here to try to do.
Without question, we're very pleased with the what seems to be the purpose and intent of these regulations. We have no objection to the direction where these are headed. We just want to make sure that licensees are, have the opportunity to not trip over.
100%. We certainly don't want to end up sending this to the commission approve it, then come to find out that people have more questions.
Right.
We're trying to do the opposite. We're trying to have people say, do I need to send this to the chair or not? And if I have very good house rules that my customers can understand and have been approved by the enforcement division, the game control board, then that's your contract. And that's what they talked about back in 1989. So let me go to the end and we'll start backwards. 22.115. Do you believe that's proper language?
Yes.
Okay. And that's really what we're trying to say here is, unless it's required, if it's not required, then the chair doesn't have to do it. If it's required, then the chair would have to rescind. Really, the concern here is, are we 100% clear on our side of the table and on the patron side of the table, the licensee side of the table, of what must be reported to the gaming control board?
Right. And it's what and when. And the other concern is the word all details within 7 days, because again, these things develop over time. They require certain investigation.
Can you repeat that one more time, Mr. Rubinstein?
The third issue, and with respect to the language, is having to report all details of such instances. All is a very bad word in terms of, we don't want to have a reg violation because we left out some minor detail that or some detail that in good faith we felt was minor or insignificant, and we didn't discover it in the first 7 days. So, what's that? I'm sorry.
About the word relevant.
Well, we were talking about, maybe some language, and again, I don't think it's appropriate to stand here and try and draft, but something to the effect that we make a reasonably adequate, conduct a reasonably adequate investigation and provide with sufficient detail for the board to understand what transpired. Again, that's very general language. We probably could do a much better job than I'm doing just throwing words out. but that's the general intent of where we think this should be. We have no objection to reporting. We have no objection to being obligated to investigate to the best of our ability, but we want it to be reasonable in terms of time and manner and work product in terms of what we're capable of before we report it to the board.
Yeah, and 3D actually talks about such other information as may be required by the chair. And
Right.
that would be something I'm sure Enforcement Division would let the industry know this is what we need to do. So
Right.
I get your point that all could be a problem as they're trying to fill out a report. Let's do this. And I'm with you about not trying to draft here at the podium. Anything else you need to tell us on behalf of yourself, your client, and your knowledge of this particular regulation, or should we open it up to other comments?
I would open up to other comments.
Okay.
I mean, those are just, again, we think not that it was poorly drafted. We just think that there are some concerns in the way it was drafted in terms of the language and the burden it puts on the licensee. And we don't want to run away entirely from having a burden, but we want it to be something that we can fulfill with.
And that's the purpose of these regulatory workshops.
Exactly.
That's why we're here. So appreciate your comments and very well taken. Let me open it up to anybody else. Yeah, Mr. Rubenstein, hold on one second. Judge Assad has a question. Go ahead.
So other than past posting and maybe minors who may slip in a bet at a sports book, what other situations have you seen that this applies to?
I haven't seen, but well, first of all, this particular regulation, I think just addresses past posting, 22060. But any illegal wager ought to be covered in the House rules as not being a valid wager and something we're not gonna pay.
I guess.
And to I don't know the entire universe of illegal wagers. I would say minor, as you said, past post. Theoretically, an illegal messenger bet, theoretically,
right,
is illegal and therefore void as a matter of law. Again, I don't have the universe of what would fit in there.
Yeah, we'll open that same question up to anybody else in the audience and the public who wants to comment on it. Anyone in the audience who wants to come up and talk about the proposed revision to Regulation 22? Seeing none, so that's nothing else to add to your question, Judge. But I think Mr. Rubenstein covered most of what it would be, and the ones that I've seen that come to the chair is past posting. It's very obvious past postings that usually get to my level. They say we need to ask for approval to rescind this wager pursuant to Regulation 22. Anybody else in the public who wants to comment on this recommendation at all? Nobody in Carson, nobody here in Las Vegas. Member Watkins, do you have questions or comments? And I'll tell you where I'm leaning right now. I agree with Mr. Rubenstein that trying to draft this here at the podium in a public meeting is probably not the right place to do it. The fact that we've debated it on a public record, though, I think solves us not having to have it in a workshop. It can be on a board agenda under our regulatory agenda item. And I would suggest that before that happens, we refer this back to the Attorney General's Office, Enforcement Division, to work with any licensee or counsel who wants to submit comments. And I would say, Mr. McKellar, if you even want to have a conversation with Mr. Rubenstein or anybody else to work on the few words in, it's actually 22.060 sub 3 seems to make the most sense to me.
I can do that.
Member Watkins?
Yes, I agree, Chair. It's kind of hard to draft on the fly on the public record, but I think given that we put our comments forward on the record, it will help with the redrafting. Did you want to consider 22.115 separately from 22.060? I think we said that there were no issues with that, or
that's a good question, Mr. McKellar. If we were to recommend 22.115 to the commission without working on 22.060, would that make sense, or should they be hand in glove?
I think it could make sense. I don't think that it's a pressing matter to pass 22-115, but I think they can be considered separately without causing harm. 22-115 would be broader than past posted wagers. It would make it clear that any house rule could create a term of the wagering contract for which chair approval of a rescission would not be necessary. But that being said, it's been the way it has been since 1989. So if we keep it as a package, I don't think there would be any harm in that as well.
Yeah, I tend to agree. Just as we submit this to the commission, we might as well put them together. And if we can, in short order, get some clarity on sub 3 of 22.060, I think we can get that on our board monthly agenda in the next month or so and submit them at the same time. That way the commission won't have to have them broken up into two parts.
All right.
And we've been doing this since 1989 and it seems to make sense. It's just a slower process. And as I mentioned earlier, and it's been brought to my attention from some licensees that with the electronic wagering, mobile wagering, things are just happening very fast. And they didn't have those conversations back in 1989. So I would refer this back to the Attorney General's office to work with Enforcement Division, Mr. Rubenstein, any other counsel or licensee who wants to put in your recommendations. Please contact Mr. McKella or the Enforcement Division, and hopefully we will see a draft of that in the next couple of weeks and get it on our board agenda as soon as possible. All right, Madam Secretary, I don't think we actually need a motion for that, or Mr. McKella will just refer it back, or I can refer it back, correct?
Correct.
Okay, very good. Thank you, Mr. Rubenstein. Appreciate your comments. Bringing us, Madam Secretary, to our next item.
The next item is proposed amendments to Regulation 5.260 regarding without limitation the modification of the initial date for new covered entities to comply with cybersecurity assessment.
Senior Deputy McGaw.
Good afternoon, Mr. Chair, members of the board, Madam Secretary. Again, for the record, I'm Ed McGaw with the Nevada Attorney General's Office here today to present the proposed changes to subsection 3 of NGC Regulation 5.260. You should have before you a draft dated May 6, 2024. The proposed amendments, this is really a housekeeping provision. The proposed amendment would remove the initial compliance date provided when the cybersecurity regulations were first adopted and replace it with a time frame by which new covered entities would have to be licensed or would have to comply. And basically, you know, when we enacted the regulation, when the board did, they wanted to give licensees ample time to come into compliance. Now, new licensees already are aware of the rule before they apply. So it was felt that a 90-day window would be sufficient to bring them into compliance. That date, of course, is up to a revision if desired. With that, I conclude my affirmative presentation and would be happy to answer any questions the board may have.
Thank you, Mr. McGaw. And I saw this as I was going through some regulations a couple months ago, and it kind of jumped out at me as well that made sense when 5.260 was passed that licensees were told you have till December 31st of 2023, but now leaving in regulation, just a purely cleanup matter, and 90 days to me seems to make sense for anybody who needs to comply. So let me first open it up to the public. Is there anyone in Carson City wishing to make comment on the change to 5.260? Seeing none, is there anyone in Las Vegas wishing to make comment regarding this proposed revision to 5.260? Seeing none, Member Watkins, did you have questions or comments?
Yes, just a quick question for Mr. McGaw again, with regard to the timing. I guess more so with regard to the covered entities. Can you reiterate for us which entities are covered and why that might relate to why the timing wouldn't be too aggressive?
Yes, Dr. Watkins. The definition of covered entity is found in Regulation 5.260, subsection 2, paragraph C. A covered entity is the holder of a non-restricted license that deals, operates, or carries on, conducts, maintains, or exposes for play any game. It is or a holder of a non-restricted license to operate a race book, holder of a non-restricted license to operate a sports book, or a holder of a license, non-restricted license to operate interactive game. We kept them to when the reg was adopted, it was the larger entities that were the focus rather than the smaller ma and pa type organizations. So this is intended to keep it focused on the larger entities.
And entities who would likely have the resources to, prior to opening, have these cybersecurity protections in place already.
And the larger entities, of course, are at greater risk of the harm, or the harm that could occur would be greater than maybe a smaller establishment. So the focus was on where's the greatest risk, who is most exposed, and certainly they have enough resources to comply with 90 days. And again, these are new applicants, so probably they'll be already in compliance. Larger entities probably for good practices already have a lot of these in place, a lot of these requirements in place.
Thank you, Ed. That's all I have, Chair.
Judge Assad.
Thank you, Chairman. Yes, since we're past December 31st, 2023, this makes good sense.
Yeah, good catch on the part of the chair.
Absolutely. And I think that 90 days, as you mentioned, Mr. McGaw, makes sense because any licensee at this level, they didn't decide to come in front of us on the first day of the month. They've been in the process of going through the licensing, the application, all of that. They should be long before 90 days of licensing already in the process of having a cybersecurity plan. So giving them 90 days after licensing seems certainly reasonable. The only thought I had was if there was somebody who said we can't get it done in 90 days, I think we would handle that, or the board and the commission would handle that. If somebody said, I'm standing before you trying to get licensed today, but I'm not going to meet 5.260. And I believe, tell me if I'm wrong, that you could condition their license to say you'll get it done in 120 days or something.
That is correct. You can do so.
I would think so. Good. All right. Then I would entertain a motion on this recommendation.
I'll make that motion, Chair. I move that the board recommend the adoption of proposed amendments to Regulation 5.260 as presented in the draft dated May 6, 2024 to the Nevada Gaming Commission to become effective upon adoption. Is that the right date?
Yes. That's correct.
Yeah, and there's a typo in the heading of operation of gaming establishments. I don't think it matters for the purposes of a motion, but before you send it to the commission, we can just fix that typo.
I will, Chair.
All right. Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye, that motion passes. Mr. McGaw, I have failed to note whether we are saying that the commission, and perhaps you did this, Member Watkins, is this effective upon adoption?
I believe Dr. Watkins' motion had that at the end.
Did you have that? And I just didn't listen very closely.
Well, I have it on my paper. I believe that I read it.
Good. Okay. I was probably looking at the typo, but yes, good. If you got it, that, and it does say on the document in front of us that effective date, effective upon adoption by the commission, and that will be handled by the commission anyway, but that is our recommendation. Very good. Madam Secretary, bringing us to our next agenda item.
The next item is proposed amendments to regulations 16.010 and 16.405 regarding without limitation, clarifying the definition of prescribed activity and clarifying the filing process for finding of suitability.
Thank you, Madam Secretary. Who is presenting this item?
Mr. Chair, that would be me.
Very good. Please proceed.
Mr. Chairman, members of the board, Madam Secretary, my name is Mike Somps with the Attorney General's Office, and you should have a draft of some proposed changes to Regulation Chapter 16 that's dated April 29th, 2024. The changes that you have before you, I worked on with the Investigations Division, Corporate Security Section. And the first change that you see in there is in Reg 16.010, subsection 17. and that amends the definition of prescribed activity. But I'll note that that is not a substantive change to that definition. Rather, what we're doing is we're taking the current statutory definition as opposed to what is currently referenced as the bill from 2019. And for ease of reference, just plugging it into the regulation. The second changes are in Regulation 16.405, and just a little bit of background here for your benefit and for the benefit of the record. As I indicated, back in 2019, we had Senate Bill 73 that was passed. One of the purposes of the bill was to establish that it was mandatory to file an application for a finding of suitability for any beneficial owner of a PTC regardless of the amount of ownership, if they intend to engage in certain quote unquote prescribed activities. Those would include things like changing management, changing policies, or changing the operation of the PTC, or otherwise engaging in activities that materially influence the PTC. And so with that bill, there were some additional changes in NRS 463.643 subsections 3 and 4. Subsection 3 previously, before the 2019 changes, required persons who beneficially hold more than 5% ownership of a PTC to notify the commission within 10 days after filing any report with the SEC that a report had been filed. The statute now requires notification to the commission on the date specified by regulation. Also in NRS 463.643 subsection 4, it previously required persons who beneficially hold more than 10% ownership of a PTC to apply for finding of suitability within 30 days after receiving notice from the board chair. The statute now requires an application for a finding of suitability on the date specified by regulation. There is no regulation that flows from these particular statutory provisions. So we're looking to adopt these regulation changes to create some clarity here and essentially match up with what the board did pursuant to the statute before it was changed in 2019 for these types of owners of PTCs who don't fall into the quote unquote prescribed activity category. So this is what I drafted with the assistance of the investigations division, and I'm happy to answer any questions.
Thank you, Senior Deputy Somps. Is there anyone in the public wishing to make comment regarding the recommendations to Regulation 16.010 or 16.405? No one in Carson City, anyone in Las Vegas? No. Member Watkins, questions or comments?
Yes, I do have a question. Thank you, Mr. Somps, for your presentation. I have a few questions. And this is in regard to subsection 6. I do have concerns with the letter requirement being added back in to the regulation while it was removed from the statute. I don't have a concern for the time frame provided for, but the letter requirement seems to add an additional burden that's not necessary on the board, but it also adds something that the legislature removed, and I think probably with reason, although you and I have taken a look at the legislative history, and it doesn't necessarily specify why the letter requirement in particular was removed. It also seems to be inconsistent with section, I believe it is 8A of the statute, which provides, except as otherwise required in subsection 4, apply for someone having over 10% must apply for a finding of suitability within 30 days after the commission requests that the person do so. So given that inconsistency, meaning that section 4 seems to be a carve out from this requirement of the commission requesting, I think that it should happen. The finding of suitability should happen as a matter of course, as opposed to the potential applicant waiting for the board or the commission to request that a finding of suitability be filed. Again, I think it is, the letter requirement is inconsistent with 8A of the statute. It also adds an additional burden to the board. And I think the legislature removed it for a reason, even though, you know, we don't have the specific legislative history to tell us what that reason was.
Thank you for that, Dr. Watkins. Based on your comments, do you believe that we should refer this back and maybe have you or any member of the public or the industry have further comments with the Attorney General's office?
I would agree with that.
Okay, yeah, rather than trying to redraft on the record, all your points seem very valid. Mr. Somps, rather than you trying to go back and forth on the record, it seems to me to be the easiest. Would you agree with that, Mr. Somps? And you can keep this on your to-do list and follow up with Member Watkins?
That's perfectly fine, Mr. Chairman.
All right, then I will refer this back to the Attorney General's office to seek further input on the exact language and to address the points raised by Member Watkins. Now,
Thank you.
something I should have done to begin with, and I apologize. Our crowd in Carson is very light, but I'm seeing the crowd here by a show of hands. Who is here on Regulation 5? Okay. Who is here on, let me go through 7A. All right. How about 28? How about Regulation 14? And then 5 would be our last one. I set the agenda a little bit earlier for some people's timing, but what I'd like to do, since the majority of people here are actually on our last item, let's take that one out of order and do that one first, so that I don't waste any of the rest of your time. And again, my apologies. I could have taken that one a little earlier. So, Madam Secretary, if you could read in Regulation 5.
Actually, at this time, the court reporter is requesting a break. Could you
Okay.
take a 10-minute break?
All right, we'll take a 10-minute break and we will come back and we will deal with Regulation 5.102 and then go back in the previous order. So we'll be in recess for 10 minutes.
Thank you. I'm back.
Okay, we are back from our recess, and Madam Secretary, let's go ahead and do 5.102 if you'll read that into the record.
The next item is proposed amendments to Regulation 5.102 regarding without limitation, clarifying the registration process as a gaming employee for armed security personnel.
Thank you very much. Good afternoon.
Good afternoon, Chair Hendrick, Member Saad, Member Watkins. My name is Nona Lawrence with the Attorney General's Office. Before you today for your consideration are amendments to Regulation 5.102 that have been developed with input from Chief Torgerson and Deputy Chief Lopez. The changes are contained in an April 25th, 2024 draft, which I believe the board members have copies of. The draft was also made public and posted to the board website on 9th, 2024. Generally, the changes in this draft are to align the regulation with the changes made by the Department of Public Safety with regards to armed security personnel gaming employee registrations. If you would like, Mr. Chairman, I'll go through the changes.
Yes, please.
First, there are proposed changes to the types of credentials that will be accepted for interim armed casino security applications. Previously, the Nevada Gaming Control Board agents were allowed to access complete criminal history and arrest reports, including warrants, through CJIS in cooperation with the Department of Public Safety. To this end, GCB would accept currently registered armed security personnel as temporary registration while they completed updated information. Because they are now not able to access the appropriate criminal records, those categories are eliminated as being suitable for temporary registration. Those categories are number 5 and 6 within the regulation. Similarly, the Nevada Private Investigators Licensing Board was also able to obtain criminal records previously. This ability was also terminated by the Department of Public Safety. Because of this, the category of applicants that hold a current registered work card from PILB, commonly known as an armed guard card, was eliminated as a suitable category for temporary registration. It was confirmed with the executive director of PILB that they are the only entity in Nevada allowed to issue armed guard cards and that they have lost the ability to run their own criminal background checks. The remaining categories that are suitable for temporary registration during the period that GCB obtains updated information are: 1, an applicant that holds a current concealed weapons permit issued by a political subdivision of the state of Nevada, commonly known as the CCW. 2, is presently employed as an active law enforcement officer. And 3, a retired law enforcement officer with a current Law Enforcement Officers Safety Act card. In short, 3 of the categories have been deleted out of the 6. Second, the language regarding the time period for the GCB to expedite the registration decision has been deleted. Previously, the board would attempt to notify an applicant within 15 days of a completed application submission. This timeline was overly ambitious, and with the number of persons applying for gaming registrations of all types increasing exponentially, this was simply no longer feasible. I'm happy to answer any questions you may have. Also present are Chief Torgerson and Agent Kevin Adams, who are available for questions and clarification.
Thank you, Ms. Lawrence. Chief Torgerson, do you want to give us a brief background on how we got here today, following up on Ms. Lawrence's presentation about what these amendments would provide?
Sure, I'd be happy to provide a little more context. Yes, we were notified by the Nevada Department of Public Safety. They advised us that Nevada Criminal Justice Information Terminals and CJIS terminals are not to be used for purposes beyond their intended scope, which includes non-criminal justice employment. As NVDPS has advised, Title 28 CFR 20.3 provides for the administration of criminal justice and CJIS terminals, and they are not to be used for checks that fall outside of it. So basically, they notified us that we were, not able to do this anymore. We weren't authorized to run the specific checks that we needed, or we would be in violation of federal law. And how that affected our processes directly, specifically, we had use of a terminal function. It was called DSPT, and it was a general dispatch transaction. It was for non-criminal purposes, but it's a composite transaction which returns information from both state and CJIS, non-criminal, which actually CJIS, which would be allowable, and NCIC, which would not be allowable from those systems. With that being said, with the practice not being allowed any longer, critical information the board will be missing is the out-of-state warrant returns, and as well as critical notice information. With that being said, there's really no way we can complete this thorough background check any longer. And so we were looking for other mechanisms to make sure that, those could stay in the industry.
Thank you for that background. And as you explained, this isn't a gaming control board issue. It's statewide, dealing with other agencies, I assume, private investigators board, as well as other boards using that computer system. And then obviously across the country as well, that I'm guessing that the federal government came in and explained very carefully what their systems would allow and what the federal law allows. Is that correct?
We did a lot of due diligence with this because I don't know that the explanation was quite clear at the beginning. So we did, engage pretty proactively with Nevada Public Safety and also with the FBI. And we even had FBI's attorneys get involved with our Attorney General. And we looked at the legal issues because that's truly what it is. It's a legal issue. And FBI did confirm the fact that, DPS is correct and on track. So with that being said, we really didn't have any other options.
Very good. Thank you for that. Anyone in the public who wishes to make comment on the proposed revisions to Reg 5? Ms. Valentine, good afternoon.
Good afternoon, Mr. Chair, Member Watkins, Dr. Watkins, and Judge Assad, and also Madam Secretary. My name is Virginia Valentine. I'm with the Nevada Resort Association. As you can see, I have several representatives from resort properties here with me today. I hope that they'll all step in and lend their specific experience. I do want to mention Eric Gobleski and Steve Martinez from Caesars Entertainment, also Michelle Rasmussen from Boyd Gaming, Jeff Sample from Stations Casino, and we also have members here from Mirage and South Point. I think you all know that tourism safety is our top priority. People don't want to go places where they don't feel safe and secure. Armed security, along with our partners at Metro, they are a serious deterrent to crime on the Strip and to maintaining that safety. They've been appropriately trained security, and they are important there for both the employees and the guests. Many of our security team members are former law enforcement, but not all of them. I want to also not be remiss in thanking Chief Georgeson. It is my understanding that everyone worked very hard to come up with a solution around the legal issue that's causing this problem today, and that we're here due to no fault in any way that was created by the Gaming Control Board. And I know she's worked very hard to answer and explain questions, but we still have concerns. Concerns remain. In particular, anything that causes the delay to registration or renewal is going to be a problem for us while we try to maintain an adequately trained and resourced security staff. So future recruitments are affected by this. Security, when they change a position or they change properties, they change locations, they're going to have to go through this process again. Those who may be retired from another state or military in another state coming here are going to also experience these delays. So I think these are going to really challenge our ability to maintain a properly staffed armed security force at the properties. In particular now, and I think noticed that in the explanation, that we're down from about 6 ways that you could be qualified for this registration to about 3, with the deletion of 5.1023A, 5 and 6. And so I think that's in particular how we kind of had been operating. I appreciate that this came out on April 25th. That hasn't given us a whole lot of time to react to it and to plan for those expirations. We'd really like to have more time to talk to you about coming up with some solutions. So we would ask that you give us, respectfully ask, it's a big ask, but that you give strong consideration to rescinding the April 25th notice to licensees and extend current registrations until January 1st. And that would give us time to work with you to try to come up with an alternative solution. We're very committed to working on alternative solutions with you. Armed security, as you know, they're essential to us ensuring the safety in the resort corridor. We work with Metro, they're our partners, but Metro only has a couple hundred commissioned officers within the Convention Center Area Command. So we are a force multiplier in a sense for them. We supplement what Metro does. We work together with them to maintain a very safe and secure environment in the resort areas. So we're asking that we have time to work with you on solutions. And with that, I'm happy to answer any questions or invite my colleagues to respond to any questions that you might have for me.
Thank you, Ms. Valentine. Gentlemen, please step up, and anybody who wants to make further comment, and then we'll open it up for questions. Introduce yourself and state your name for the record.
Good afternoon. My name is Eric Golubieski. I'm the Corporate Vice President of Security Operations for Caesars Entertainment. I agree 100% with what Virginia said. We are a force multiplier. We have a lot of passion in protecting our tourists who come here and visit our properties, and also our team members, and protect them from any harm that may come with our armed security forces. We work very collaboratively with the enforcement team, with my colleagues, the other licensees, security chiefs, to ensure that really the community is safe when they come to the resorts. Some of the issues that we experience or are starting to see from the change is the issue with recruitment that Virginia talked about. We recruit a lot of young men and women that are ending their contract with the armed forces in different states and relocating to Las Vegas. They're looking for that first job in the private sector. And they really come to enjoy working in the armed response team for us or one of the licensees that has that position to protect. That'll put a damper on us because no one's going to wait 180 days to get their concealed carry permit, and they're not eligible for the other options. They're not active law enforcement, and they can't get the HR 218 under that Law Enforcement Safety Act. We also get and recruit a lot of law enforcement that are either retired or just changing careers and moving to the Valley here in Las Vegas. And they have to get their concealed carry permit for whatever reason. They don't have their HR 218. So that recruitment process forces us to run a lot of overtime. The team will end up getting burned out, or there's gaps in coverage if nobody signs up for that overtime. Nobody knows the resorts. I mean, we'll obviously supplement with LVMPD at the resorts, but nobody knows the resorts like the security armed team members that work there. If we told you to go to this and this buffet, some of those police officers never been there and they can't respond to an incident without help from the property security. So it's very important to have those response team members there. And the other thing I guess we're asking for is if they were working in armed security capacity this year, if we can reinstate them, because we currently placed a couple of the team members on unarmed security until they can get their concealed carry weapon permit. If we can reinstate them because they had already been working in that capacity. These individuals go through a psychological exam. They go through an extensive training that is far beyond what is required to get that concealed carry permit. Because the job is so difficult with congested space and mass crowds and mass gatherings and active assailant situations that could occur that they're prepared for. So that's what I'm asking for.
Appreciate
I'll turn it over to my colleagues.
Thank you. Good afternoon.
Good afternoon. Jeff Sample with Station Casinos. I don't really have anything to add. I think Eric kind of put it all very well together as far as the challenges it creates for us. But I do agree to answer any questions.
Thank you. Good afternoon.
Good afternoon. My name's Steve Martinez. I'm a retired Chicago police officer, currently working for Caesars Entertainment. I'm in charge of their special response team. I'm directly involved with the hiring of my team members. As my boss mentioned, we had several of our officers who became unarmed when this came out. I have 40 officers working for me. 8 of them became unarmed who were working armed in the beginning. So it drastically affected us. They're all currently getting their CCWs and stuff like that. One of my other big concerns is our military. You know, we have a lot of guys that are coming out of the military looking for jobs, as mentioned, and we have to overlook them. We tell them, thanks for coming for the interview. You need to get your CCW, and it's going to take you several months. And, you know, so we're missing good quality people. So I totally support giving us more time so that we can, you know, help better solve this for everybody. Thank you.
Thank you, Mr. Martinez. Let me ask you a question. You said you had armed security. 8 of them had to go to unarmed?
Yes, we received the letters from the board stating that they are to be unarmed. So they were recently hired.
Recently hired?
Yes.
And so we hadn't had the opportunity to use the prior computer system? Is that what happened? Just timing wise? Because if we'd used the system back when we were allowed to, let's say 4, 5, 6 months ago, those armed security would still be licensed, registered for 5 years.
Correct.
But you're talking about 8 people fell
Yes.
within the cracks.
Yes. Well, we actually had, they were recently hired, and then we have an extensive training program. So it takes almost probably 2 months before we're actually deploying them into the casinos.
Yes, understood. Thank you for that. Yes, please go ahead and step up and introduce yourself. Good afternoon.
Thanks, sir. My name's Skip Wilkes. I'm Chief Security at South Point. Just like to clarify one thing. So they had some recent hires that got the notifications that they could no longer be armed security officers. They they got moved out to the side. I have some people that came up for renewal who have been armed security officers for in excess of 10 years. They don't have a CCW, or we're in the process of getting them one, but because they came up for renewal at this time, they're no longer allowed to be armed until they get a CCW. So it's not just new hires. It's affecting people who've been doing this for a significant amount of time.
Thank you for putting that on the record. And that's my understanding as well, as new hires, it's renewals, and then it's transfers to other properties. And that we don't have the system to be able to do a background check. And I'm completely with all of you. Safety of our community, our visitors, is absolutely paramount. And some of that goes along with obviously being sure that those that we allow to have weapons and carry weapons are safe and secure as well. And it's a bad position that we've been put in. And as you all have noticed, we were scrambling as well, as the chief mentioned, and working with a lot of other law enforcement agencies, working with the federal government to try to figure this out. And is not an easy solution to any of this. I'm interested in, you can go ahead and have a seat. Thank you. I'm interested in what our options may be as to those three categories: new hires, transfers happening now, and people who are coming up for renewal now. As he mentioned, 10 years been carrying a weapon, but now we can't do a background check on them to see if they have, I'm assuming you're talking about active warrants. What else would we be looking for?
Yeah, we'd be looking for active warrants outside the state. So we do have, in-state warrant.
Yeah.
We can run those still, but it's about the liability for, what's happened in other states when they've vacation, or if they've traveled, or if someone, exited the military and if there was an issue. It's a picture in time, right? Just the liability there is what's concerning. I have found it fabulous to work with industry partners and our stakeholders, because they're trying to adjust now to support these registrants. We have, I know Stations Casinos, I believe, actually is doing an in-house training to facilitate the training so they can get the CCW part of that training done quicker. I spoke with Under Sheriff the other day, and he basically said to me that yes, they're looking to see if they can expedite some of this somehow during this, transitory period, because that's really what it is. It's a transition primarily. We weren't given a grace period, unfortunately, for this system use. So the minute that we were notified, we had liability if we used that system improperly. As a law enforcement agency, we're breaking federal law. So we came up with what we could for solutions, and now it's kind of a reactionary period, right? We have been working with human resources departments too, and security chiefs, to say, if you know that someone's going to be coming up and expiring, you should front load that. So go send them to get their CCW 6 months or 8 months out. That way they have it upon the time that they have the renewal. But I mean, that's all to mitigate. It's the best that we've been able to come up with so far. As far as recruitment, I think that's a legitimate concern. I respect what the the industry is doing out there as far as security for the city and the community. And I do think that's a concern. I don't have an answer for that at this time.
So to Ms. Valentine's recommendations of, could we extend the time of somebody who, let's say, expires on a renewal? Could we even do that legally? And this may be a question for you, Ms. Lawrence, Mr. McGaw, Chief Deputy Caruso. I know this regulation comes from 463.335 to be registered. And what we're talking about is actually temporary registration. This isn't registration. They've been registered. We would allow them temporary registration while we had time to do this background. Is that something the Attorney General's office wants to come up and talk about? Can we extend it'd be the time periods under 5102?
Thank you, Chair. I don't have that answer right now, so we would have to look into that.
Thank you. Yeah, and to the other point of rescinding the notice, it really comes down to, can we temporarily register somebody longer than the reg allows? I don't know if we can do that. And the reg, again, is based off the statute. What we're trying to do with this is just say these categories don't fit anymore because we can't do it. It's a matter of you can't get approved on something that we can't check. Let me go back and ask you again, Chief, out of state warrants, what else are we missing from what we had 3 months ago?
I believe that we can cover our liability with all the other tools that the current terminal functions were allowed to use. I don't see that as a problem because every 5 years, we're going to get new fingerprints. With that being said, we're going to run criminal history. We have ability to access in-state warrant information. It's the out-of-state. So when we look at our liability, that could be something to consider as far as a policy decision. If we don't have the tools to access out-of-state, do we really have a liability there? And are we comfortable with not having that information and allowing this change to be made? That could be an option.
Did we have Interpol international capability to begin with, or we were checking United States?
Just the United States.
United States, and that's what CJIS was allowing us to do. Ms. Valentine, do you have something else to add?
Virginia Valentine for the record. I do appreciate what the AG is saying, and I think we could take a deeper dive into possibly some of the legal arguments if we were given the time to, possibly looking at some way to amend this regulation to allow more than those 3 categories of people who could get something, and the possibility of extending a temporary license. So I would hope you'd give us an opportunity to have some more dialogue on this. This is a serious problem for us. So, and I do want to thank you for your time today. And I know you've all worked really hard to solve this problem before we got to this point today. But, and I do wish I had a solution for you today, but unfortunately, sort of hitting the pause button on this and giving us some more time, possibly some temporary registration extensions, that would give us the time probably to come up with better solutions. So thank you again.
Appreciate that. And yeah, we're
bringing us forward, and I'm really glad we won't be sitting in these chairs for much longer and I hope they're not moving to the new building with you. But
you don't like the chairs. These chairs probably came with the building, so hopefully they stay with the building. Yeah, and I appreciate that. I mean, your comments and all of you gentlemen from the industry as well. It's a tough spot, and we certainly don't want you recruiting, lacking the ability to recruit qualified people because the system doesn't work. And the other side of that coin is we can't not follow our own regulations, our own statutes. We just don't have the authority to do that. These are the commission's regulations and obviously the legislative statutes. So we can't run afoul of that. To the question, this might be to you, Chief Deputy Caruso, is there an ability to extend the temporary time period under 5102? And you're probably going to have to do research, is my guess. It's so specific. One of the things we're trying to take out is that it says we have to do something in 15 days, which is almost impossible. I don't know if we have the ability as a board to say, we would like to not take this action until, 60 days, 90 days, January 1st, whatever it might be. Good
Thank you,
afternoon.
Chair, for the question. Darlene Caruso from the AG's office. I think what we need to do is go back and look at the statute, make sure we're not running afoul of anything in there before we agree to what we can do with the temporary registration. If there's no restrictions there, we might be able to work with some of the issues that are presented today.
Yeah, and you're talking about 463-335, right?
Correct.
It's you have to be a registered gaming employee unless you're a temporarily registered gaming employee,
right,
which is what this reg deals with. It was designed to say you're temporarily registered while we go through this background. I don't know how you don't run afoul of 335.
Yes,
if you
so
say
we
you
need
can
to get
extend
creative.
temporary.
Right.
Yeah, if you don't mind, take a look at that. I can't imagine that we have an ability to do anything because what we're doing is we're making recommendations to the commission. They wouldn't even take this up without a 30-day notice. So they're not even having the opportunity to look at this till possibly their maybe July agenda, but more likely August to change the regulation. But as you noted, they'd still have to be in compliance with 463.335, even if they did. So yeah, I would encourage you to look at it and work with Ms. Valentine, any of the licensees on possible other solutions. That's not a quick fix, though. That doesn't fix the people, new hires, transfers, or renewals. Doesn't fix any of that. The question about could we rescind our industry notice, that was more just telling them that we don't have the ability to do what we used to do. And Chief Torgerson, feel free to jump in if I'm missing something. We're not saying that you can't be temporarily registered. We just don't have the ability to use these other categories.
That's correct. Yeah, we just don't have that mechanism anymore. We don't have the flexibility. We don't have the tool. So, you know.
So let's think creatively. If we're missing the other 49 states' ability to tell us whether or not a temporary registrant has an outstanding warrant, what other ways can you legally obtain that?
I don't know of any other way other than through that terminal check. You know, it's FBI's database, and the administrator for that, for law enforcement purposes, is NDPS. So it really comes down to the sheriff's office who has that access, and also the Brady unit.
That applicant would be able to tell us what states they've lived in, but they wouldn't be able to tell us what states they might have committed a crime in.
I mean, some of it comes down to our comfort level, correct? I mean, if we don't have that tool, and, you know, the example was I have a security officer who's been armed for 10 years on property. The property is standing up for that individual. And, you know, if he's been a Nevada resident for all that time, you know, it just comes down to a level of comfort with the policy decision on that.
Interesting. Yeah. And I don't know if temporary registration even allows for that. We have a regulation that says you're temporarily registered if you fit any of these 6 categories, which have now turned into 3. But even at 6, we had to do some work as a gaming control board.
And we're happy to do that work in support of the industry.
Sure.
It was never a problem. We'd be happy to do it today if we could.
We just don't have the ability. Okay. Anybody else, after hearing that probably unenlightened conversation, have anything else you want to add? And I'm open to all kind of suggestions, but you can see where the state is put. We have a statute says you have to be a gaming employee registered or possibly temporarily registered. Then the commission said, this is what a temporary registration is. If you fit one of these categories, you're temporarily registered. Now we don't have the ability to do that. I just don't know if we have a chance to extend it. The board doesn't have that opportunity. And I guess the only question would be if somebody transfers or renews, that maybe there's a way to say you are temporarily approved. Ms. Valentine.
Virginia Valentine and Chair Hendrick, that is what I was going to suggest, that you could add categories that made exclusion. People who had been temporarily could be extended if they have, you know, changed locations, or they've been promoted to a different job, or they've possibly been employed for some certain period of time with no problem. So just so that there were some other criteria that would maybe make you feel more comfortable or reduce what you feel like is your liability. So I just say that I think that's kind of where you were going, and we'd certainly appreciate it if you could.
Yeah, and that possibility works if we make recommendations and include the categories you mentioned and get them in front of the commission, and they have a public meeting and they approve it. That doesn't do anything between now and the people, the examples of the real world that's going on out there right now. Doesn't fix anything in the next 60, 90 days. And we can't take action. Today's a regulatory workshop. We can't take any action. The industry notice was more of a, I want you to know we can't approve people by using CGIS anymore because we don't have access to it. But the midterm solution, I think, does make sense. And we could look at that if somebody has been renewed twice. So they've had a armed security license for 10 years. We're just running up into a little bit of a foot race. You got the foot race to get a CCW versus the foot race of taking away their weapon before we can change the reg. I don't know which one of those wins the race.
Well, Virginia Valentine, I thank you for your consideration. Even that would be probably better than where we are now. Again, we'll do some thinking about it too, but would appreciate consideration.
Absolutely, absolutely. Member Watkins, do you have questions or thoughts? Solution?
I don't have a solution, unfortunately, but I do have questions in hopes of finding a solution. I understand what a problem this could be, a significant problem for the industry. And I do have a pointed question for one of our AG's office folks. And I understand that you don't have the answers and you need to do the research, but I just wanted to know if you knew off top whether that 5-year limitation is only in the reg or is it also in the statute? If you don't know, that's fine. I just thought that might help make some headway.
We believe it's in the statute, but we will definitely double check that.
Okay.
Yeah, as do we.
Okay. And then I do have a question, and I don't know if we need everyone who's representative of the industry to come up, but I would like to get a better idea of how many armed security guards are being employed at the properties and what percentage of guards are armed versus unarmed. So if a few of you want to come up and address that with the chair's permission, then I'd appreciate that.
Please state your name again for the record.
Eric Olbieski, Caesars Entertainment Security. We have 60 armed security personnel for Caesars properties.
And how many unarmed?
Oh, gee, probably 500, 600.
Tell me I'm sorry, the total is what? What's the total of security guards altogether?
Altogether, it's somewhere around 600 to 700.
All right, now armed?
Armed is 60.
And unarmed?
Somewhere around 600, I would say.
Okay.
It just fluctuates seasonally, pool season, nightclub season, depending special events.
And how long do you have an estimate? And I can turn to our enforcement division here too for maybe statistics about how long it has been taking for you to receive approvals from our enforcement division.
I don't know the time frame. Steve Martinez, our Caesars SRT program manager, would probably have more insight on that.
Hello, Steve Martinez, Caesars SRT program manager. Yeah, typically we would probably be within maybe 30 days or so prior to our training being completed. It fluctuates.
I'm sorry, you said prior to your training being?
Yeah, when our guys get hired, we go through a training process. We don't typically arm them and put them on the floor. We run them through several different academies. We run them through a firearm.
Talking about the letter. How long do we get the letter that they've been approved?
Yeah, it's hard to say. Typically I would say within 2 months.
Okay. Does that sound about accurate from our enforcement division?
For the record, my name is Kevin Adams. It's about 15 to 25 days once we receive the rap sheet. So we have to wait till we get the rap sheet. So when they submit it versus when we actually get the rap sheet in from DPS from mail and processed, I would say about 15 to 20 days of us giving them a notification that they can be armed. And that's via postal mail, sending a letter through the mail.
How long does it take to get the rap sheet?
Depends, sir. If it's live scan, which is done electronically and forwarded right to DPS, we can have it in as little as 2 weeks. If it's a manual card, it can be, I've seen it all the way out to a couple months. It's lost in the mail, DPS prints it, shreds it by accident, so we have to actually request a reprint. So there's a lot of factors that can vary that time frame.
Yeah, and it's hard, as mentioned, it's hard to put an exact number on it because some come quick and some come a little later.
Yeah, I completely understood. Would you say that these are happening faster than the 120 days that we've allotted, that we would allot?
Yes.
Okay. And then if we could just have someone else from the industry come up and tell us your numbers. Just trying to get an understanding of the scope of the issues too.
Jeff Sample with Station Casinos. We have about 400 security personnel, and about a third of those are armed. And that's if all positions are full.
Okay. Thank you for that.
And Member Watkins, I just wanted to mention as well, it is a statewide problem. You know, our northern properties, we do have one specific property up north that has armed security guards as well. And, you know, throughout the valley here and in the south, you know, we have large properties, obviously, but we also have smaller properties like Jerry's Nugget, you know, and I think as far as recruitment, they've got some real issues too, because maybe they're not as competitive with wages. And so I just wanted to let you know the diversity of that problem, and it is affecting our licensee statewide.
And what about can you give me more insight into the armed security up, the property that has armed security up north?
That would be Grand Sierra Resort.
And are they experiencing issues with the federal prohibition on access?
So we've been coordinating with our office supervisor up in Reno, and she handles all of that for the northern properties up north. And she said right now, you know, I think they have some concerns just as much as we've heard here. I know they haven't spoken up today. There's no one in Carson or Reno, but yeah, I would say once again, it's a statewide concern.
Okay, and while I have you, I just want to back up a bit and clarify the issue with the system access. So it's not that we can't run criminal background checks using the system in general. It is, it has to be limited to law enforcement purposes. Is that correct? So we can't use it at all for employment purposes.
Correct. So the particular function that we're restricted from using today, the DSPT, that was something that we utilized on both sides of the house. We're no longer able to do that. So we can use that when we have our officers or agents out on the strip and they need to run wants and warrants based on, you know, coming into contact with individuals. But we cannot use that terminal function for licensing or registration anymore.
And so you mentioned the term non-criminal justice employment before. So define that for me.
Non-criminal justice employment?
Yes.
So any type of licensing or registration, non-criminal relative to that. So as a law enforcement agency for criminal justice purposes to, you know, support our operations as law enforcement sworn officers, we can use that. But for just employment or background checks, we cannot.
Okay. And the chair mentioned earlier that one of the things that we would be looking for on these renewals might be the out-of-state warrants. You mentioned toward the beginning, I think in your overview, something about a critical notice. Is that something different than the?
It is. That would be your sex offenders, your DONS files, dangerous persons. That was included in that DSPT as well. But even though that might be of concern for us, once again, it may not violate federal law like a convicted felon would. Right? So, yes, of course.
Ma'am, so in essence, that DSPT function allows us to hit on NCIC federal information. So that would include, like she said, dangerous offender notification, terrorist watch list information, and the federal system will not allow us to access those systems for non-criminal justice purposes. So if I'm rolling through the casino and I have somebody in custody, I can run them every which way I can because I'm wearing my law enforcement hat. But then when I go back to the office and I'm working in the background investigation unit for the purposes of employment, I can only do a SQCH screen, which is a state criminal history screen under the purpose code of E, which is for civil employment, for licensing.
Mm-hmm.
So it just restricts us to this state. So if we don't have this function, if we were to tell somebody that they could be armed, we could be telling somebody that they could be armed and they have a domestic violence warrant out of California, even though they're right there, because we can't hit that NCIC federal file.
Or be on a terrorist watch list.
Terrorist watch list as well. So it can have all those, like I said, it's a bunch of NCIC hot files that system touches, and we can't touch any of them for our non-criminal justice purposes, our background investigations for employment.
Okay, and I recognize that the industry said that it would be an issue as far as recruitment and concerns, and that seems like a, a valid concern. I'm just trying to understand who would, because one of you specifically mentioned, I can't remember who it was, but that your recruitment, many of your armed security guards come from out of state, and so they're retired law enforcement individuals. Are none of those individuals, do they not fit under subsection 3?
Correct. They have to apply for that HR 218, the Safety Act, or my understanding is they had to be current law enforcement in the state of Nevada.
Oh, okay. Is that accurate? Is that they have to be?
Yes, but that HR 218, you can have an HR 218 or the Safety Act card from Atlanta. As long as you have that card and they supply it, we'll honor that. Because that's a federal act that covers law enforcement retired law enforcement throughout the entire United States.
That's the key, though, is retired.
Correct, not separate, just separated, just retired.
Yeah.
Okay.
There's a criteria there. I don't know the specifics of it, but I think you have to have worked either 7 to 10 years in a law enforcement agency to be eligible for that. And then you go through the process, and then you have to qualify every single year to renew that particular status.
That's correct, and it is 10 years.
10 years.
So then I would assume if you're not very familiar with it, then this is probably not something that many of the out-of-state officers would qualify for.
We get a lot of law enforcement from smaller agencies across the country, sheriff's departments in different counties across the United States. And then we educate them. We just had a few and told them about the process, walked them through the process to get it. So that we can get them back armed. And we're doing the same thing with the CCW. We brought people in and started going through the process because we want to kind of bridge that gap, to get them as fast as we can back working in an armed capacity.
Okay, and then final question, how fast can you get a CCW? That's up for grabs.
Depends on who you know.
Right now, I've been told it's running anywhere between 120, 180 days. Is that what kind of what you've
That's
heard?
exactly the information we received too.
And although they may try to expedite it, once again, you have working under the constraints of, those terminal checks, but also the fingerprints and the return on, right? So some of that, it's not going to matter how fast Metro moves. They're happy to try to help expedite these and prioritize these possibly to get us through the transition. But, the check takes as long as it takes to get that information.
Is that the slowest piece, the getting the return on the fingerprint cards?
I would say yes.
Yeah.
One other thing I wanted to note too, it does affect some of these registrants' pay because a lot of times, of course, you're getting paid more in an armed capacity than you would be if you're an unarmed security officer. And so I have heard some of the properties are actually still paying them to be armed, even though because it's of no fault of their own. So I really appreciated them stepping up for those registrants as well. But once again, that's a business decision, and all these properties are different with their training and their ability to recruit.
Thank you. Judge Assad, did you have questions, comments?
Yeah, does anybody know what the rationale was for this change from DPS?
Judge, we were told that basically it came down to just an auditing function. So every year we get audited as a law enforcement agency. And I think, just the fact that we're kind of a hybrid here where we do both, right? We have law enforcement function, but we also do employment checks. And I think that, there's two different sides of auditors working for DPS. And I think as they've transitioned with new people coming in and the education has increased, they just kind of caught it. And then they noticed that it was a problem with other agencies within the state as well. So once again, I think that's always been the case. But as far as the interpretation and the application and communication to agencies, I think that's where it's changed.
How many years have we been using CJIS until this new change took place?
I would say over 20.
Yeah, it seems kind of weird to me. All of a sudden, they just realize, oops, we some auditor from
I think that's
Harvard
why
or something, some
we work so
25-year-old
hard with
kid from Harvard who got an auditing degree come up with this.
you know, I really can't, I can't speak for them. I can just say that's why we pushed back a little bit and wanted the clarification because we've been doing it quite some time and, you know, and we followed their guidance. We have to, or we'll lose our privileges.
No, I get that. So, how many regarding the out-of-state potential warrants? How many of those have we had in the last year?
Out of state warrants last year.
And how many have we screened?
I
Roughly,
don't have an
ballpark.
number
Just
screen,
ballpark.
all of them so far this year. 6,000, 10,000, 20,000 applicants thus far this year, statewide.
Not armed though.
Now,
Total.
Totally.
Armed.
Correct, our system doesn't break it down for you. We have
Correct.
to do more.
The current system doesn't break it down. I have to go to IT to get exact arm numbers.
So what if the hiring folks at the casinos would ask the applicant, do you have any outstanding warrants in any other states? And if we find out you do, you're going to be terminated. Would that give anybody some level of comfort?
I think with that being said, we don't have universal security screening practices, but if we were to adopt something like that, we definitely would need to hear from the industry and our stakeholders on their feelings with that. Whether we feel that would mitigate our liability completely as an authorizing body, I don't know, but it's always something to discuss.
I mean, they say fortune favors the bold. I think there's a way that we can find some accommodations and way to at least maybe extend this to January 1st. Is that what you wanted, Virginia? And allow the industry to, serve and protect the public and their own employees. So, I mean, I'm in favor of anything that gets us to that place.
What do we think other states are doing if they're properly following the federal law? What is New Jersey doing to find out if their armed security don't have warrants in other states?
I think the way agencies like ours is, across the states, I don't know that, I think we're pretty unique in the way we're structured. A lot of times, things like this will fall under, law enforcement. That's completely law enforcement. They're not doing the background checks. And so it's really divided. But I would have to do some research. I don't know the answer.
Let me ask you, gentlemen from the industry who have properties outside Nevada, how do they check to be sure that your employees don't have warrants in states beyond their borders?
We don't have any armed, the Zerko Bieski Caesar, sorry. We don't have any armed security outside of Nevada. We'll typically just hire law enforcement officers because typically Nevada's the leader in allowing this and coming through the process.
Understood. So if you need armed security, are they off-duty officers or are they former officers?
It depends on the contract and the jurisdiction. Typically, like in Baltimore, Maryland, we'll have a contract with the police department there. Some agencies don't allow their personnel to be on duty, and you have to hire them separately and create an agreement. So it's very different across the United States.
Kind of like a vent department or division at Metro here, where they're working boxing events, big concerts. They get hired to provide Metro on-duty police officers for that event.
Correct. Even like with the Baltimore property, there's a substation right in the resort itself. So it just depends on the property and the agency if they allow it or not, and how they want to proceed in staffing that particular property under their collective bargaining agreement with the police union in that jurisdiction.
Understood. And this, if we had more time, probably wouldn't be that big of a problem. You would just tell your armed security that you have to have a CCW to be considered. It's this moment in time that we're really dealing with.
That's correct. I think everybody got caught off guard with the audit and the immediate transition that had to happen, which created this unique problem.
Yeah. And a little bit in the future, even if you, like you said, you want to hire somebody, but you say to them, you can't start till you get your CCW, and that's going to take 120, 180 days. So a little bit of distance in the future, but right now we're dealing with several months of people that you've got currently armed security that may have to be unarmed next week.
That's correct.
Yeah.
Yeah, we're changing advertisements on the recruitment to say, make sure you get your Nevada concealed carry weapons permit before you apply. So candidates know that that's a requirement and can start taking the steps to do that.
Right. Yeah. Thank you for that.
Thank you.
You have other questions, Judge?
No, just maybe if AG's office could look into possibly extending this out to January 1st of 2025. There's some way to accommodate Ms. Valentine.
Yeah, absolutely. And same for us. I'm happy to dig in, fully understand the issue a little bit better than I did before I got here this afternoon. Understood that it was going to be an issue for new hires and that it would slow down some of that. And as you all agree, as Billy Joel said, we didn't start the fire, right? But we're all in it right now. Didn't fully understand your great example of somebody who's been a 10-year armed security officer and was told, because you don't have a CCW, you are now an unarmed, and then you have issues of coverage for what you need of armed security, the pay scale that the chief mentioned, a lot of issues. So I'm happy to dig in as well with the Attorney General's office. Again, because of open meeting law, we cannot make a decision today to do anything other than what we're agendized for is a recommendation to the Nevada Gaming Commission. Doesn't mean that we couldn't add more categories. It's just not going to solve your time problem for 15, 30 days, 60 days. So I would say on this, I want to hear from the other board members, obviously, but I don't think we need to move forward today. We can also put this on our next agenda meeting, but this doesn't solve the problem. Let me ask you, Chief Torgerson, if we don't make this amendment today, does it cause a bigger problem?
No, I think we need to do everything we can to support the industry. And I think right now they're working it out. They're dealing with it. I think there's a lot of repercussions, consequences, and problems. But by forcing this today without maybe exploring the better solutions, I think it would be remiss to make the decision today.
Let me ask the Attorney General's office. If we move forward with this today, we take one step closer to the commission, and the commission can obviously make changes at its meeting. Would it at least move forward where we are in reality? If we were to make this recommendation to the commission, doesn't mean that they have to pick it up on their agenda or couldn't change it. But it seems to me that we get one step closer to fixing our black and white document, but we don't fix the problem.
I would agree with that statement. Darlene Caruso for the record, but yeah, I would agree with that statement.
Okay. Yeah. All right. Thank you. As far as members of the public understanding all the issues that Ms. Valentine and you've all raised, is there any problem with the recommendation of changing the regulation? Understanding we have to take out certain pieces that you've all heard about today. And then we talked about the fact that the board just can't simply get its work done in 15 days. Any reason we shouldn't make these recommendations, still giving the board a chance to change them later or the commission a chance to change them later? This would move it closer to the commission if we did have instead of 3 categories, may we come up with a 4th or a 5th? Any other reason you don't or have an issue with the words in the revision?
Virginia, Valentine, Chair Hendrick, as I understand what you're saying, by moving this forward closer to the commission meeting itself, we are allowing for some changes to be made, but we are not extending the timeline by pushing out that commission meeting. Is that
correct? So if the commission can only take action on recommendations from the board after they actually post for 30 days. So if we don't take action today, they couldn't even consider it until after they post it. If we took action today, we would get a little bit closer to that. Also would give the board a chance to maybe put it on our next agenda if we wanted to add something. And Attorney General's office can correct me if I'm wrong, but I believe the commission on their own agenda could say, we've taken the board's recommendation, we posted for 30 days, but we would like to add a category 4, category 5. And I'm seeing nodding, so I'll take that as this would move it closer to the commission. Doesn't again solve our current problem, but it may get a chance to have them do something. I don't know if they would have the ability to do the you can be temporarily registered through December 31st, but it's something that we could look at.
Virginia Valentine, and I do appreciate that. And I think if there's an understanding at least that we're going to be able to work on what some of those changes could be, and the ability to maybe put the brakes on it if we're not able to come up with some constructive additional categories to allow for temporary or extended licensing.
Yeah, absolutely. You and anybody from the industry who wants to be involved will definitely be involved. Let me ask you though about your question of putting the brakes on it. Are you concerned more about the fact that we can't do the background check, or are you concerned about this being the only 3 categories?
I'm concerned about the opportunity to amend in some relief by either adding other categories or working something into the
Good.
3 that are already there. So
Understood. And then I
that makes sense. And can I look at my group here and see if
please.
Good with that? Okay. Yeah.
Good.
Looks
Yeah.
like we're on the same page.
Okay, good. Then I think if we do make this recommendation today, it will move it out of our regulatory workshop. The board, correct me if I'm wrong, Attorney General's office, the board does not have to put it on its board agenda if we make a recommendation from a workshop. So we do get, we get a little closer to the commission, which has timeframes that are set in statute. So I think taking a recommendation today and moving it forward to the commission will at least get us closer, and will certainly not forestall any communication, any continuing conversation about resolution of the problem we have.
Thank you, Chair, and all of you, Chief Torgerson, AG's office. We just do want to retain the ability to, I don't want to say take another bite of the apple, but at least to add something in or to consider amendments that might, that we didn't think of here today, because this did come on to all of us pretty quickly. So
Yeah.
just appreciate the ability to continue to work on the language if we're going to proceed that way. So
Absolutely. You have my personal guarantee that we won't be doing something without having a discussion with you and members of the industry that this is affecting you in real time. So we will continue that
Thank you
conversation.
very much.
Good. Anything else from the Attorney General's office that we need to add before we make a recommendation? Good. All right, then, unless board members had other comments about language presented for Reg 5.102, I would entertain a motion.
I'd just like to comment, Chair,
Please.
that I think moving forward on this today would allow us to remain in compliance with our federal obligations. So I think it is important for us to move forward on this today. But also, as you mentioned, would help to shorten the time frame within which this could get in front of the commission. So happy that the industry, to hear that the industry is in support of that. But
I would say, I mean to interrupt, but you're absolutely correct. We need to be sure that our regulations, the commission's regulations, are not saying that we're in violation of federal law. So good point. We need to move forward to say we are following federal law, and we've always been doing that, and we always thought we were. To the judge's question, if it's been 20 years or 25 years, we always believe we were doing the right thing. But if we need to modify this regulation to make that very clear, you're absolutely correct. We should do that.
Absolutely. I'm happy to make a motion.
Great, please.
And there were no changes to the language suggested. Is that correct?
Ms. Lawrence, thank you.
It's been a long conversation. I couldn't remember.
Yes.
Okay. I move that the board recommend the adoption of the proposed amendments to Regulation 5.102 as presented in the draft dated April 25th, 2024 to the Nevada Gaming Commission to become effective upon adoption.
Very good. Madam Secretary.
Member Thad,
Aye.
Member Watkins,
Aye.
Chairman Hendrick.
Aye, so that recommendation passes, and we appreciate all of you being here today, and we'll continue to work with you, and hopefully we can resolve this in the short term and the long term. Thank you all. All right, Madam Secretary, let's go back to where we were before we took 5.102.
The court reporter is requesting a 5-minute break.
Okay, we'll be in recess for 5 minutes. Thank you. All right, we are back on the record after our recess. Senior Deputy McGaw, is this next one yours? Madam Secretary, have we read it into the record?
We have not.
Please go ahead.
The next item is proposed amendments to Regulation 7A regarding, without limitation, the replacement of hearing officer with hearing examiner.
Thank you very much, Senior Deputy McGaw. How quick can you explain what happened in 7A?
I will try to make this as fast as possible. Good afternoon, Mr. Chair, members of the board, Madam Secretary. For the record, I'm Ed McGaw with the Nevada Attorney General's Office, here today to present the proposed changes to NGC Regulation 7A. You should have a draft dated May 6, 2024 in front of you. This is a housekeeping matter. The proposed amendments would replace the term hearing officer throughout NGC Regulation 7A with the term hearing examiner. And this change is necessary to be consistent with the terminology used in NRS 463.0163 and throughout Chapter 463 of the NRS, is to make the regs match the statute. It's not clear why these terms were different, but they were, and this would bring Reg 7A in line with the statute. And in addition, throughout the regulation or throughout the draft, various non-substantive edits are being made to correct or modify cross-references and other items to bring them in line with the standard format used in NGC regulations. With that, I conclude my affirmative presentation and would be happy to answer any questions.
Thank you very much, Mr. McGaw. I guess the other substantive change was 7A.050. It talked about by one or more members, and now it'll say by the board or a hearing examiner. It was kind of
That's because a hearing examiner by definition includes one or more board members. So there's no need to have that.
Yeah, very good. Good cleanup. And yeah, I was with you. Sometimes we were calling them hearing examiners. Sometimes they were called hearing officers. I've heard patron disputes. I've heard player disputes. So very clear that you have a hearing examiner who can be designated to preside over a patron dispute. So thank you for the cleanup language. Is there anybody from the public who wants to speak on this proposed recommendation? Carson City, seeing none. Las Vegas, seeing none. Board members, questions, comments?
Real quick question, Ed. What is the difference between an officer and an examiner?
It's not really clear. From what I can tell is it might have been done, and this is speculation, at the regulation level because it was to distinguish when a single board member was doing it versus a hearing examiner. They used the term hearing officer to combine the two, but it really wasn't necessary because hearing examiner at the statute level includes a board member or one or more board members, or a hearing includes one or more, or a person appointed by the board as a hearing examiner. That was it.
So we were using the term hearing officer, and that could have meant someone appointed by the board or someone on the board. Is that what you're saying? Or
I'm thinking that's the only, and this is speculation on my part. I apologize. I don't know that for sure, but that was kind of what I assume it was meant to cover both.
Yeah, they were just being used interchangeably, but the statute says hearing examiner. And then if you looked at 7A, it started talking about hearing officer, and there's no definition, no description of what a hearing officer is. So it should be called a hearing examiner. That's all this is. It's cleaning that up.
Yeah, I'm happy to make this consistent with the statute and move forward with this recommendation if my colleagues agree.
Great. Judge Assad?
No questions. Thank you.
All right, then I would entertain a motion on this particular recommendation of Reg 7A.
Okay. 7A as a whole, or are we taking this in? Is it?
However you want to make the motion. I think we can do all of it unless Mr. McGaw wants us to name each specific section.
No, you can just simply say the amendments to Regulation 7A as presented in the draft dated, and then that will cover just those changes.
Perfect. I move that the board recommend the adoption of the proposed amendments to Regulation 7A as presented in the draft dated May 6, 2024 to the Nevada Gaming Commission to become effective upon adoption.
Madam Secretary.
Member Assad?
Aye.
Member Watkins,
Aye.
Chairman Hendrick.
Aye, that recommendation passes. Bringing us, Madam Secretary, to the next recommendation.
The next item is proposed amendments to Regulation 28 as noted on the agenda regarding without limitation modifying the processes for the list of excluded persons.
Senior Deputy McGaw.
Again, good afternoon, Mr. Chair, members of the board, Madam Secretary. For the record, I'm Ed McGaw with the Nevada Attorney General's Office here today to present the proposed changes to NGC Regulation 28. You should have a draft dated May 6, 2024 in front of you. And if it pleases the chair, I will briefly summarize the proposed amendments.
Please.
First, the most substantial change is that we go through the entire regulation and update the terminology used in the regulation to match the language found in the statutes. And just for the record, the various terminology have been used. When the statutes were originally drafted in 1967, it originally stated any licensed gaming establishment. In 1977, this language was amended to include licensed gaming establishments that operated any game or conducted parimutuel wagering. In 1979, it was further amended to, and it added that it made it limited to licensed gaming establishments that operated, in addition to any game or parimutuel wagering, also a horse race book or a sports book. And at that time, race books were referred to as horse race books. In 1981, an amendment was made to exclude slot-only locations, and this was due to a court ruling that prohibited the state from interfering with the person's right to interstate travel. At the time, bus stations and the airport were slot-only locations, so this fixed that problem that excluded persons could go through bus terminals or airports. And lastly, in 1985, it was amended to remove the word horse before race. So those were the changes in the statute over the years. So what this will do, and I guess just as an oversight, the regulation was never updated, or it was updated in parts, but not entirely. So this would fix that. The proposed amendment to subsection 3 of NGC Regulation 28.010 eliminates the list of examples of types of reports that can be used to provide evidence of a person's notorious or unsavory reputation. This was not an exhaustive list. It was felt that it was unnecessary since the general language of the statute includes any report that's generated by a local or national agency. And it was felt that the list might be outdated, and it really was not necessary to list it out. The general language covers everything. The proposed amendments to subsection 1 and 2 of NGC Regulation 28.020 simply replaces any with to match drafting rules adopted by the LCB and to make consistent with other drafting rules of the NGC regulations. The proposed amendments to subsection 1 of NGC Regulation 28.030 clarifies the process the board actually follows when determining whether or not to nominate a person placed on a list of excluded persons. This is the current process followed by the board, and it's in compliance with the open meeting law. So we just basically codified the current procedure. And last, the draft also proposes various non-substantive changes to the language and cross-references to align to the current format used. With that, I conclude my affirmative presentation and we'll be happy to answer any questions the board members may have.
Thank you, Mr. McGaw. Very succinct. Appreciate that. Is there anyone in the public wishing to make comment regarding proposed recommendation to Regulation 28? Anyone in Carson City? Anyone here in Las Vegas? Seeing none, I appreciate you at the Attorney General's office going through this, as well as want to commend Senior Policy Counsel Sebastian Ross, who did some research into all of these listed crime commissions and reports in 28.010 sub 3. A few of these investigation and commissions still exist, believe it or not, decades later. But as you said, Mr. McGaw, doesn't need to be a list. couple decades ago, they listed a few that would meet the requirements, but the regulation as written says it could be any body that provides evidence. So doesn't make sense to have a laundry list when you don't need it. So appreciate that being cleaned up. And the rest all looks pretty simple to me. It's just clarifications. Member Watkins, did you have questions or comments?
Just a comment, I'm in support of moving forward with this recommendation. As I agree that, the statute no longer refers to it as the horse race book. So getting rid of that term would be consistent, and also getting rid of the list so that we don't have to continually update, or so that outdated organizations can be removed. I think that provides for efficiency. And also with regard to the open meeting law issue, I think it's, this is simply updating the reg to be consistent with habits that the board currently practices. So I'm also in favor of that as well.
Thank you, Judge.
Yeah, could you clarify that open meeting law issue?
Well, I mean, it removes any doubt that it's in compliance. Let me pull up my draft here. Basically, each board member shall independently, just to clarify that it's not, when it just said first informally, it just makes it clear that each board member on their own will be reviewing the evidence in its possession, so that there would be no deliberation among the board members or collectively reviewing that evidence except on the public record. After an opportunity for such review, the board shall, at a public meeting, make a determination whether there is sufficient reason to believe that any one of the criteria specified in the NRS is applicable to the candidate, and whether or not the candidate shall be placed on the list. That is something that is deliberative and needs to be on the public record. So that's what the board has been doing.
Yeah, I was going to say, isn't that the way we've been operating?
Yes, but the way the regulation was worded, it didn't make it clear, that process, that it is going to be transparent, it is going to be open. And then the last sentence is removed. At least 2 board members shall concur in such decision at an investigative hearing, but no formal meeting of the board shall be required. That has never been implemented, and it's not clear whether that just wasn't necessary anymore. This isn't done in an investigative hearing.
And to be extremely clear for the record, every time this has come before the board and the commission, open meeting law has been followed.
Exactly.
And some of this was extraneous, but the open meeting law was followed and the regulation was followed. So everything's completely correct. This just puts the wording in compliance with open meeting law.
Yeah, and it makes the process a little more clearer to the public of what the board actually does, so that they're aware of it as well. Yeah.
And you indicated one of the amendments was to exempt a person on the list of excluded persons list. He was exempt from restricted licenses?
It was never
Said like the
restricted.
airports.
Restricted was never one of the categories. It was always non-restricted licenses.
Yeah.
And originally when the Reg 28 was drafted, it matched the statute language.
Right.
And over the years, the statute language was modified, but those modifications didn't always come into Reg 28. So what this just does is clean that up. Like if you look at example 28.040 subsection 1A, it used to say every licensed gaming establishment with the state that conducts parimutuel wagering or operates any game, but it didn't refer to the race book, sports pool, and then other than a slots machine only. So that would have gone back to a iteration of the statute that was amended in 1977. So in 1979, they added racebook and sports pool. That change was not brought over to 28.040, and it should have.
So let's say a person is on the list of excluded persons because he's been a notorious slot cheat and he's placed on this list. So he can go into like a 7-Eleven here in Las Vegas and play slots?
Currently under the statute, Yes. So what would have to, if you wanted to prevent that, you would have to have a statute change. And then they could theoretically bring in restricted locations. They would just have to modify that other than slots only to be only like a public transportation center, like an airport or a bus station.
Right.
That the legislature can't get around that because
Right.
that's,
It's federal.
yeah.
So do you think that would be a good idea for a
Uh,
BDR?
I mean, it depends on how material, you know, if you would probably want to have to factor in, or the legislature probably would factor in whether or not that's a reasonable restriction, the risk of harm at a 7-Eleven. I mean, the person couldn't go to a convenience store. That might be a little bit farther than what the legislature wanted to go. It's up to the legislature. I don't really have an opinion on whether that would be reasonable.
And you're crossing over a little bit to the judge's question into restricted versus slots only, which this is specifically talking about non-restricted slots only, which is interesting with your historical background. I think I had heard that many years ago about why it's slots only, but I had forgot that very good point. If somebody wanted to travel and you had slots only in an airport or bus station, they couldn't go anywhere. So thanks for bringing that up. Forgot.
And you know, it is interesting. The legislature might not be worried about 7-Elevens, which are restricted locations. There are non-restricted locations that are slots only.
Yeah, like a Dottie's.
And some other properties that are grandfathered in, or, you know, so maybe the legislature would want to revisit that given the modern floor.
As written, you're correct. You could go into a slots only location with a non-restricted license. Yeah.
And again, as the judge points out, a lot of the more recent people added to the list of excluded persons have been convicted of slot cheating. So it is relevant to the machines. You know, I mean, that we wouldn't want them able to gamble at slots only or on slot machines. So
I would just add the consideration that, you know, if this were to cover restricted as well, then that may prohibit a patron from going into a grocery store, let's say, and, you know, I would argue that that's an unreasonable restriction. I don't know the legislative history on this, but people need to be able to go to the grocery store for obvious living necessities.
But if
you could word it that they can go into the grocery store. They just can't go into the gaming area in that grocery store.
I mean, yeah, they could also do that on restricted locations too. It would have to be clearly defined in the statute and how far away from the machines. It'd be like a restraining order. It can't be within 50 feet of the slot machines. But what if the door's right there?
Or you can't
especially
play,
in a
just say you can't
store.
play the machines.
Yeah,
I mean,
it could be as simple as that. At restricted locations, they cannot play or loiter in the game, like a minor.
Well, and there's a burden on the licensee.
Yeah.
The licensee has to affirmatively look for people on the list of excluded persons. And it's a gross misdemeanor if the person knowingly goes onto the property, but it's an unsuitable method of operation if the licensee isn't actively looking for and removing them from the property.
Slot route operators might have a difficult.
That would be more difficult in a grocery store. But to your point of slots only non-restricted locations, that's a good point. That may need to be clarified that it's except for public transportation facilities or something, because some of these slots onlys have up to 100 machines, 150 machines. Yeah. Good point.
And this time we'll make sure to update the regulation should a statute change occur.
If we do that every 47 years, we'll be in good shape. Good. Anything else, Judge?
No, that's it. Thank you, Ed.
All right. Thank you, Mr. McGaw. Anything else you need to add?
No, thank you.
All right, then I would entertain a motion on this recommendation.
I will make that motion. I move that the board recommend the adoption of the proposed amendment to Regulation 28 as presented in the draft dated May 6, 2024 to the Nevada Gaming Commission to become effective upon adoption.
Madam Secretary.
Member Hassan?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye, that recommendation passes, bringing us to, I believe, our last proposed recommendation, correct, Madam Secretary?
Correct.
All right, Read that one in, please.
The next item is proposed amendments to Regulation 14.010 regarding without limitation the removal of a term no longer referenced in regulation.
Senior Deputy McGaw, is this yours?
Yes, last.
All right, go ahead.
Good afternoon, Mr. Chair, members of the board, Madam Secretary. For the record, I'm Ed McGaw with the Nevada Attorney General's Office here today to present the proposed changes to NGC Regulation 14.010. You should have a draft dated May 6, 2024 in front of you. This proposed amendment repeals subsection 1 of NGC Regulation 14.010 to remove the definition of assumed responsibility as the term is no longer used in the regulation. Should be noted that the term assume responsibility is defined on statute. So this doesn't affect anything as far as the definition. As a result of the repeal of subsection 1, the remaining subsections of NGC regulation 14.010 have been renumbered accordingly. With that, this would become effective upon adoption. With that, I conclude my affirmative presentation and be happy to answer any questions.
Thank you, Mr. McGaw. Chief Barbie, any real world explanation you need to add for the record?
Jim Barbie, for the record, no, Chair. There, nothing further to add.
Okay, simply a term that's no longer needed in Reg 14, correct?
Correct.
Housekeeping matter. Good. How many years, Mr. McGaw, have we had this on the books that we don't need it? Above or below 47 years?
I believe this is probably under 10.
Good.
Yeah, yeah.
All right. Anybody in the public who wishes to make comment on Regulation 14.010 recommendation? Carson City, Las Vegas, going once. Member Watkins, any questions or comments?
Yeah, Ed, do you have I'm sorry, Mr. McGaw, do you have the language of the definition?
Of assume responsibility, I can look it up, but I don't, if I can recall from memory, there's two phases to it. The manufacturer has to take complete control or ownership of, or
Yeah, there's two conditions for assumes responsibility in the statute where a licensed manufacturer can assume responsibility for the activity of an unlicensed manufacturer. And generally, the first is that you have to have complete control or ownership of whatever that activity is or whatever that product is. And second, you have to assume continuing legal responsibility.
Okay, just wanted to know substantively what we were removing, and I'm in support of removing it as well.
Judge Assad?
A whole history of assume responsibility I've dealt with it many times over the years.
No questions.
All right, then I would entertain a motion on the recommendation regarding Regulation 14.
All right. I move that the board recommend the adoption of the proposed amendments to Regulation 14 as presented in the draft dated May 6, 2024 to the Nevada Gaming Commission to become effective upon adoption.
Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye, that recommendation passes as well. And we already handled Reg 5.102. So we referred back a couple and we have recommended several toward the Nevada Gaming Commission. I believe the only item left on our agenda, Madam Secretary, is public comment, correct?
Correct.
All right. Go ahead, read that in.
This item is placed on the agenda to give the public an opportunity to comment on gaming-related matters. Anyone wishing to address the board may do so at this time. Comments by each person are limited to 3 minutes as a reasonable time, place, and manner restriction. If board members ask questions of the speaker, the time needed to address those questions will not count against the speaker's 3-minute time period. If speakers have any handouts or written copies of verbal comments to provide for the record, please hand them to the enforcement agent seated to your left in Las Vegas or behind you in Carson City.
Thank you, Madam Secretary. Is there anyone in Carson City wishing to make public comment this afternoon? Seeing none, anyone in Las Vegas wishing to make public comment? I would just like to say I want to thank the Attorney General's office, all of the Deputy Attorney Generals for all your hard work putting this together. This is quite a number of regulations that, as we noted, some of them haven't been fixed in 40 or 50 years. So thank you very much for your help, as well as all the chiefs from all the divisions, the agents who helped work on this. Senior Policy Counsel Ross. A heavy lift, and hopefully we can move this forward. I'm anticipating that our next regulatory workshop may be in a couple of months. So anything we didn't get done today, we can either put on that agenda or we will put on the board's regular monthly agenda. But again, I personally want to thank all of you. A lot of hard work goes into this and makes it look easy for us once you've put all the facts and background and history in front of us. So thank you very much. Anything else from board members and public comment?
Nothing further from me. Thank you to everyone.
I would just like to echo your comments and thank everyone as well.
Very good. All right, then that will conclude our regulatory workshop for today, which is May 23rd, 2024. And I appreciate everyone being here either in person or virtually, and do want to also thank the members of the industry and the public who did come and testify today. Always welcome and enjoy their comments, because they're giving us the real world example of how these regulations work in the industry and for the public in the state of Nevada. So thank you all. That concludes our workshop.